see him collapse over in handcuffs there at the side. Sits there dying. Not a word from any of these 5 men about hit to the head, trauma to the head, or anything. Did they wake up that morning? There will be no proof that they woke up that morning planning on killing somebody. Like I said, not monsters, but men, overcome by anger and frustration and overcome by the moment, who literally beat a man to death, and they all had a part. Can we agree that Martin was the worst? Yeah, we can. But they all had a part, and they all had a legal duty to stop it. Tyre Nichols is the victim's name. We're going to ask for justice for Tyre. This happened because these officers were overcome, reason 1. And reason 2, because they didn't know that pole camera was there. Justice for Tyre. These men, reasonably certain that the side kick to the head, the next kick, the huge haymakers while they hold them, reasonably certain to cause death, that's murder second. Each and every one of them is criminally responsible for 2 reasons. They took part in it, but even beyond that, they had a duty to stop it. Aggravated assault acting in concert. 5 of them. They cause serious bodily injury? Yeah. Did they do it together? Yeah. Did they have a duty to stop it? Yeah. Aggravated kidnapping. Not talking about ransom notes.
Kidnapping.
It's the illegal confinement, the false imprisonment of a person that either causes bodily injury, or the people doing the false imprisonment have guns. They're Memphis police officers, they have guns. They're not alleged to abuse the guns, but the fact that they're armed is one of the elements of aggravated kidnapping. Is a police officer allowed to arrest somebody? Of course they are. Maybe even earlier they were allowed to arrest Tyre Nichols. But at some point,
why would this guy get new permanent teeth in 24 hours? Instead of placing you in temporary teeth, you get your permanent teeth in 24 hours.
Legal arrest anymore. Tyre is purely and 100% a victim, and those men have him in prison falsely while they keep on hitting him and kicking him. Those men have him in prison falsely when he's handcuffed next to the patrol car, and they're not even telling the medical personnel about the head wounds.
Oh, wow.
Official misconduct. They had a duty not to do this. Official oppression. They had a duty not to do this, and they put Tyre through hell. At the end of this, that's what we're going to ask you for. Justice for Tyre Nichols.
Justice for Tyre Nichols. Justice for Tyre Nichols. Wow.
Mr. Perry, you ready to present your opening?
I am, Your Honor. I am. Okay, please, court. Yes, sir. Mr. Hagerman just described a relatively simple situation. Mr. Hagerman described a relatively easy case. If you look at an overhead camera, and if you start off with the notion that they didn't know that it was there, these trained men that on a nightly basis go out into the most dangerous areas of Memphis, do the most dangerous job in Memphis, are supposedly not aware that the cameras that they rely on in doing their job over and over again is not there. That is a got you moment. That would be okay If Mr. Hagerman had stood before you all, looked you in the eye and said that Darius Bean, as he's out there on this, be on the lookout.
Okay, how they look at
Who
it.
has been tased, pepper
Horrible.
sprayed, and overcame 3 officers. If he had looked you in the eye and told you Darius Bean has to hit start on his body-worn camera to record it, it would be close to not disingenuous if Mr. Hagerman looks at you in the eye and says, you know, that camera that's 100-something feet in the air doesn't really capture the story as well as the body-worn
Please come in
cameras,
hitting the
because
like
you can
button,
hear
please.
the 59
Thank you.
times that he's asked to give his hands. If Mr. Hagerman does not describe the fact that while he's on the ground doing whatever he's doing, that Mr. Bean has just run 80 yards with 40 pounds of equipment on, trying to capture somebody who made eye contact with him, and he asks him, hey man, and as soon as he gets the word man out, he takes off running. It would be an easy case if that night they didn't report to work on Flickr and discuss the fact that they had a spike in crime in that particular area, and that's where they're going to. They say their prayer, and they get out of there, and they go to those particular areas because
Say their prayer.
their work is important work.
Did he say their prayer?
It doesn't mean
Oh,
that
wow.
we are dirty. And he continues to say, I'm not calling them monsters. He can't call them monsters because y'all got common sense. He can't call them monsters because the evidence does not bear the fact that these men are monsters. I will start with what I agree with. I agree with the fact that they left Flecker going to East Memphis. I agree with the fact that there was a person seen speeding, a suspect. I agree with the fact that this person drove 2 miles after Emmett Martin, who delivered blows, etc., cut on his blue lights and his sirens. What I don't agree with the fact is that there is a mystery regarding why he was ripped from a car. When he decides to drive 2 miles away from blue lights and sirens, it is high risk. These men are trained to engage in high-risk situations. And when you are engaging in a high-risk situation, you cannot go up to that window and say, ma'am, please get out of the car. You just can't do it. You
Hey,
get the
stop
person
playing.
out of the car based on your assessment of that situation, based on your training. It's that simple. Does that. Now keep in mind, whatever happened on that first scene, getting him out of the car, that he was sprayed, and et cetera, let me tell you what he wasn't. He wasn't hit. He wasn't punched. Nobody pulled a pistol at him and said, I'm going to blow your brains out. He wasn't tased until he got up and started running away from these officers. So let me be clear. While that stuff is happening, let me tell you who wasn't there. Darius Bean. Darius Bean is 3 miles away with Demetrius Mills, who you'll hear from probably today, on another stop with a guy with a warrant. And just like the other 400-odd arrests that he had made over the last 365 days, there wasn't an incident with it. He's made an arrest because the guy had warrants. He's doing what he's supposed to do. And guess what they do? They hear a call out over the radio, and this is a very important point. There is no back room, back alley type of let's go behind closed doors and everybody throw the body-worn cameras. We're going to give them some 1960, 1970 type of justice. This is a call out over the radio by officers. Man has been tased, pepper sprayed, approximately 6 foot tall, 6'2" it turns out, and weighed about 180 pounds. So he might be the smallest out there, but I have news for you. That's an SEC wide receiver size. That's the size of a person who's athletic, who has the ability to run and to overcome 3 grown men. It's that simple. So the fictionalized stuff will stop this week. And you will have the ability to listen and to assess the situation.
Oh,
and
this
you
is
will be able
horrible.
to assess it like you're doing it on a January 7th cold night at 8 o'clock, rainy night, ground wet, and guys that only want to make it home to see their families and loved ones doing the best job that they can do. So, while Tadarius Bean is on this site and they're about to arrest the person who's in custody, who they're making small talk with, and he's saying, yeah, you gotta do it. What do? They have to let him go. Because when you hear that bolo call, when you hear your person who you just had prayer with and just talked about going out into the world to do what you're supposed to do in the city of Memphis, when you hear somebody say he's been tased, pepper sprayed, and he's got away from you, it tells you one thing. It's danger. Let's go. And so what do? They go. They drive that 3 miles and they start trying to do their job. You will see evidence that's clear that Tadarius Bean, they said, well, you know, they didn't have a talk about trying to hurt somebody. It's just the opposite. They don't want to hurt anybody. They want to make it home. They want to be safe. And they want to do their job effectively. And that's all you're going to hear about. So at 8:32, the first interaction that Tadarius Bean has with the person who subsequently will become Tyre Nichols, he makes eye contact with him while sitting in the passenger seat of a 2-man vehicle. And he does what he has to do or he'll get fired. He doesn't have the option to say that this person on the bolo who just took off running, that, you know, I need to figure out if he's got a pistol. I need to figure out if he's got a knife. I need to figure out what he's got. He doesn't have the ability to see 6705 Ross Ridge and what you're all going to be able to see this week, Mr. Nichols hiding behind cars and leaving objects. He doesn't have that ability. So he doesn't know what he's left because, you know, unless he can have a crystal ball and say, hey, my job,
Hey,
I'm
Travis.
going to make it home. All he has to do is to get out of the vehicle at that time and run like hell to try to catch this man on a dead sprint with 40 pounds worth of gear.
Y'all already know how I
and
feel
he
about
does.
this one.
Now, let me backtrack, because normally I don't try to talk about, and I know my
Memphis.
friend Martin over here is going to talk about what Justice Smith does. But there's a telling point in this.
Dirty cops.
Justice Smith
Dirty
drives
Chief.
up while Mr. Bean is driving down Ross Ridge in an
Marcus.
That's one
Thornton.
question. Where he at?
Dolph's brother.
Which way did he go? Which way did he go?
Looks
No
like
conversations, no nothing, but he went that way.
Tyre
because he
Nichols.
knows that my partner
Overkill.
in arms might be out there trying to apprehend this person nakedly. And they arrive on that scene simultaneously, and they take him down. Now, there is a 3-minute struggle. You'll get a chance to hear all of that. You'll get a chance to hear the body on camera. But keep in mind that Tadarius Bean cut his camera on. So you're not trying to kidnap. You're not trying to ag assault. You're not trying to rob or murder or anything else somebody when you are recording yourself. You'll see you'll see Tyre Nichols do everything but get his hands. He reaches up. And does he get kicked down and then beat down and all that? No. They slap his hands 4 times. Hands away from the vest of Tadarius Bean. And then they try to get him. Now, he talked about a recurring theme. This recurring theme of being pepper sprayed. Mr. Mills will come up, and Mr. Mills will testify about he pepper sprayed himself. If he's truthful and is consistent, he's going to also say, I pepper sprayed that whole area. And these other guys who didn't get a chance to go take a break and catch their breath and all this stuff, you know, you'll hear information about that first scene, and you're going to see Mr. Hemphill on that first scene. You're going to hear him hocking phlegm for an hour because he was pepper sprayed. He's not able to catch his breath, blowing his nose over and over. But during that time,
so he gonna beat him because the pepper spray got on him.
Tadarius Bean. Tadarius Bean, then you'll hear about him. Graduated from the University of Mississippi, 2020. He goes to the academy in 2020 in August. January of 21, he graduates and he starts as an MPD officer. He was a patrolman too. He had no write-ups before that night. He had no complaints against him before that night. He had no issues or accusations of misconduct before that night. Had no verbal or written reprimands. He took his job dead seriously. He's assigned to Team 1 of the Scorpion Unit.
Gotta watch
which,
the
by
company
way,
you keep.
is considered the best of the team in the Scorpion Unit. And he's the youngest member. and you'll get a chance to see what Tyre Nichols has done. And I don't want to get into
What Tyre Nichols?
prior to
Oh, they
that. I
killed
don't
me
wanna talk
moving the
about who he was and all
goalposts.
that. It ain't my business.
He is a victim, and now you want to know what his background is. It don't matter.
2023, that he drove 2 miles away from blue lights and sirens. He was at Highway 385 in Riverdale. He drove all the way to Ross in Rains. You'll see that he ran from Beam after making contact. He refused to stop. He refused and resisted arrest. He was actively resisting the whole time. And you can ask the question yourself, does he have a right to do that? Does he ignore the lawful commands of the officers that are involved? Was he actively resisting by running and walking and pulling away from Beam? And you will get a chance to see the actions at 6705 Ross Ridge prior to the interaction with Detective Beam. Scorpion Unit, street crimes operation to restore peace in our neighborhoods. You'll see who it was, the brainchild of C.J. Davis, the chief.
Oh,
It was created in 2021.
the brainchild.
Consisted of 3 teams. It focused on statistics related to crime spikes in certain areas. And Team 1 was sent to these dangerous places.
Please come in, hitting
to
the like
sometimes
button.
execute warrants and things like that. It was effective. Knocked the murder rate down 18.5 according to Chief Davis.
Well, we know she tells stories too.
18.5%. Went from 303 murders during the year before to 258. I've told you about the meeting on Flickr and what they did in the interim. You can go to the next one. You will get a chance to look at policy and training. You'll see MPD policy. You'll hear terms like active versus passive training. Passive resistance training. High risk stops. Your testimony regarding the response to resistance policy of MPD, and you'll hear about hard hands. Now, kicks might not be the most tasteful sounding thing, but kicks are number 1 in the hard hands policy. It just is. And they follow the policy. You'll see the use of force continuum. You'll hear test questions that were given through the MPD Training Academy and how they discuss things like tunnel vision. When you're trying to look at a person and you're trying to hold on to them and you're focusing on one thing while other things might be happening. And you'll see training regarding the taser usage and when it's most likely to happen and when it's done the right way. And you'll hear about handcuffing. You'll see the difficulties of handcuffing a person who does not want to be handcuffed. And it will be consistent testimony that is one of the most difficult aspects of the job. It is what it is. You'll see aspartame usage training. Now, Mr. Mills might have buyer's remorse regarding it or whatever, but the fact is, on that particular night, he deployed his aspartame and he used it the way that they train you to use it. 3 strikes to the arm. If it doesn't work and give planning compliance, you put it up. That's what he did. Now, go to the next one. You'll get to weigh the witnesses. Some witnesses might not want to take a chance. They say, hey, you know what, I will do a plea. And that's their business. That is not in any way attributable to Mr. Bean. You can't say, well, he said he's going to do one thing and then talk about it, but you'll have an opportunity to weigh why Mr. Mills is testifying a certain way. And you'll get a chance to ask certain questions. But as it relates to Bean, the consistent thing will be there's never anybody saying that he's ever done anything wrong, illegal, that he used excessive force in any way, and there won't be much criticism of his actions on that particular evening from Mills or any other witness testimony if it's consistent with how they've given statements in the past. Next one. You'll also get to hear expert testimony. When you hear expert testimony, weigh it properly. This is what we ask, and questions like, how many times have you testified as an expert? Is this the first case or the first facts that you've ever given expert testimony regarding? And then their knowledge of certain things like human factors, fatigue, tunnel vision, resistance level, body movements, center of gravity, those types of things. Those
They've
are
already
questions that
been
the
found
expert
guilty
will
in
need to
federal
talk
court.
to you about.
I don't.
And you'll see videos.
Woo!
You'll see videos
They're
that were
gonna.
turned on by the body worn
Memphis
camera
is
of
finna
Bean,
be obsolete
Mr. Mills' body worn
in a
camera.
minute.
And you'll then have a syncing mechanism where you'll hear the voices and see what's going on even with the sky cam. Next. During the time frame, there are two kicks, as Mr. Hagerman talked about earlier. And this is that relevant three-minute period that they're struggling. 2 kicks, 3 uses of the aspartame, 5 strikes, all by people other than Mr. Bean.
So he's only
And then that
representing
window
Bean.
tightened, but it's the same amount. 3 hits with the aspartame, 1 with an open hand, 2 punches. The punches are done by Mr. Martin. And you'll see that we're talking about the punches happening within a 13-second window. So while they are holding one hand that's cuffed, one hand that's not cuffed, you'll have expert testimony about the danger of releasing the hands. Because if you release a cuffed hand or a hand that's uncuffed when a person has a cuffed hand, he has a weapon way more dangerous than anybody on that scene. The jagged edges of a handcuff can kill you. Now, this will isolate the actions taken, and it's just a demonstration of what you're watching from that scene and from the video as it relates to the movements made by Tadarius Bean. It's just what you saw earlier. And you can write down the specific times that I ask you to give some focus to. And that's at 20, 33, and 57. That shows that Mr. Nichols is blading his body. And it shows that Tadarius Bean, while having been pepper sprayed earlier, is simply holding on to him. You'll see the amount of times that if he wanted to deliver some kind of punishment, that he could have punched him or kicked him or done something other than hold him, trying to get his hands into compliance and cuff. You'll also hear it as it's going on, as he's saying, give me your hands, man. Give me your hands, bro. Come on, give me your hands.
Can we approach real quick, Josh?
I was trying to say, what you saw that? It's a sad situation. It's very sad. Brutally beat him. Cop was having a bad day. And the witness is one of the Scorpion unit guys. Yeah, it's sad. I thought they had found them. That was for the federal. This is for the state. They do double time in prison. So that's why they was out. Pending the outcome of the state. Yeah, they double, triple in trouble because they got a civil suit as well. Yeah, Memphis got some issues. That's why they murder rate in 1 week was what, 36 people?
So a few seconds later, this is at 20, 34, and 12. Once again, look at where the hands of Mr. Bean will be.
I
Now,
didn't know.
the demonstrative is simply for you
They
all
better
to see
put
the
him
evidence
under the
that are
judge.
cited
Oh,
in
yeah.
24, not
They beat
as
him.
any sort of
Ooh,
evidence that
wow.
when the court allows. But look for his hand placements during that time. And that's seconds later when Mr. Martin comes up and he does kick once at his head and once seems to land.
Comes in kicking with them boots. We found out in that other situation that that's a deadly weapon. Yeah, I don't want to see that part of it. It was horrible.
This is when Mr. Mills comes up and he tries to deploy his asbaton. Keep in mind, you will get a chance to hear the video, the audio, and of the body-worn camera, and you'll see why they are placing their hands.
And then the parents and the family have to live through this again and again and again.
To try to avoid him getting hit in the head by accident, so he can have a clear shot at the arms for pain compliance. And you'll see, but you'll get a chance to see that. But that's 20, 34, and 56. That's when the first strikes from the baton is being deployed. Second strike, as he turns his body a little bit more, is for that arm to be the target that's intended. You'll hear the evidence about how they are trained for asbaton placement when they're trying to make a person comply. Now, you'll have the opportunity to see how Mr. Nichols gets up, whether or not he stood up on his own.
How do
or
you
whether or not
live with
somebody stood
yourself
up.
after this?
During this time, one of the hands have been handcuffed. The other hand has been freed. Mr. Bean has grabbed him by the waist, and that's at 20:35:08. At 20:35:09, I want you to look and be able to isolate how his body movement, in particular,
Please
his
hit
center
the
of
like
gravity,
button,
and what
please.
he's trying to do, and you make that determination. But look for his body and his body
Yeah,
movement
you have to
in
pray.
the center of gravity, and how it is pictured there is how we'll picture on that video as Mr. Nichols continues to try to move away. At 20:35:10, you make the determination on whether Mr. Bean is trying to take Mr. Nichols back down to the ground, or if he's standing them up as the state has indicated. You see that center of gravity, and you'll look at it on your own, but remember those particular times because it tells the complete story. And that is one of the hands, as I indicated earlier, one hand is cuffed, one hand is not cuffed, but has the potential for him to be free, and that creates a danger for the officers. And you'll have an opportunity to view that complete video. And that just isolates what's at the top.
Woo!
So, you heard during Mr. Hagerman's presentation the sad realities of it. no one is here to in any way diminish the fact that a person's life was lost.
Okay.
Simply saying that that person's life was not lost because these officers had some bone to pick or some gripe.
Oh, wow.
Or trying to do something punitive to this person. Simply trying to do their job based off of the information that they had.
He was detained.
Only knows what came out.
He was detained. Why did the guy come up and kick him in the head
Only
with
strikes his
the
hands
boot?
during the time when he first arrives, and you'll see it on the body worn camera of both Mr. Mills and Mr. Bean. Mr. Bean has been pepper sprayed just like Mr. Mills, except he doesn't have the luxury of walking off for a minute and coming back.
But he
like Mr. Mills
pepper sprayed
did. Mr. Mills
himself.
says that he was angry
The
regarding
detainee
the
did not
fact
pepper
that he
spray
wouldn't
him,
get his
so
hands,
you beat
so
him
he used
extra
the
because
baton out of anger.
the
Only
wind
to
blew the
against
pepper
himself.
spray in
But
your
that's
face.
not Mr. Bean saying hit him with an aspartame. More importantly, he hit him in the area that Mr. Bean was trained that Mr. Mills was supposed to have hit.
It was an unlawful stop. He hadn't done anything. Y'all
Kind of
forgetting
glossed
to
over
say
it because
that.
It was on the PowerPoint. But you will see that the training under the conditions that these men faced, having been pepper sprayed and having an active resistor, MPD policy and MPD training trains you to administer
Hey, Max to the
blows
boogie.
way worse than anything you've seen. The training of Bad Bob has never been in any way shown in the media or anything like that. You all will get to see it. And you will see how these men are trained under these conditions and what they are supposed to do.
He had
under
been
the conditions
detained.
according to their training.
Why did he kick him?
And we're simply asking that you not create some account of the actions that they were supposed to have taken in the cool, calm light of this room versus men that are acting under their training and discipline on that particular night. And with Mr. Bean, I'm going to give emphasis to this as I sit down. Consider the fact that he had no prior incidents of anything. And on this particular occasion, he did not have the option to say, no, I'm not going to try to chase, and I'm not going to try to put handcuffs on this man. It's that simple. And I think that if you apply the law the proper way, all 7 counts will be not guilty. They're trying to do their job.
Not guilty.
Or job.
Wow.
Ladies and gentlemen, the jury, your lunch has arrived, so we are going to take a break for lunch. We will come back, we will finish the opening statements and proceed with the case in chief. We're going to go ahead and allow you all to step out. If you can please.
Let me go back to the beginning while that we missed while they're at lunch.
Going to introduce that in his case in chief. The text message between Haley and another third party in which he asked her to delete the photo from her phone. The state's not going to introduce that. The text message between Haley and another third party in which Haley...
Those text messages. Let me go back.
The N-words, I hate my...
Now, he is also the attorney that in the YOUNGDOLPH case. Did I go back too far? You can kind of see my little do-rag.
Is that the only text message that you were planning?
And then, I left something out. Mr. Haley, Mr. Leffler also filed a motion with regard to a couple other text exchanges surrounding this picture. So let me go ahead and put these on the record here. This is a text message between Haley and a third party that's labeled Exhibit 2, in which he asked her to delete the photo off her phone, and she responds that she already had. The state's not going to introduce that in his case in chief. a text message between Haley and another third party in which he asked her to delete the photo from her phone. The state's not
Deleting photos from the phone. Hiding
text
evidence.
message between Haley and another third party in which Haley makes a statement. F the N-words, I hate my own race. This was sent well in advance of the Nichols case, and the state does not seek to introduce that text message. A text message sent to another a police officer in which he later apologized for sending the photo because he says he did not intentionally send it. The state does not seek to introduce that. But then the one the state does seek to introduce as far as the substance of the text exchange is the one in which the third party asked who beat him up, and Haley responded, "He did, all six of us." That is the text message you're talking about.
Yeah, so thank you for that. And the only one I'm talking about is that I've already addressed in court. That's our decision.
All right, so, all right, we do not agree though by, I guess, affirming or responding to it.
They currently at lunch, so I rewinded it back so we could hear the beginning.
He didn't make the statement, I did this, I beat someone up, but when asked if he, who did, and he just responds, we did, and then the court would find that is adopting that statement as far as an admission. So the court, if there is the proper foundation laid in that, with regard to hearsay, the court would find that to be an admission of the party. So the court would not withhold that statement, at least on that basis, unless the state were to not lay a strong foundation, should they? Yes, sir.
Judge May, just very briefly on that, I think I may or may not have, I think I may have joined in his motion as it relates to the statement the six of us did.
Yes, sir.
To say that that would be confusing, misleading to a jury of who those six are, and an admission that he's making on behalf of 5 other unknown people, I mean, that's a real stretch. And so I'm just saying that from its probative value, the six of us did. What six? I think people start getting lumped into a boat based upon Haley's alleged admission against himself. Now, if that wants to be used against him, and the judge rules that way, you rule that way, so be it. But I think
They telling on themselves, and they don't want their admission
causes all sorts of confusion, and it's
to
unfairly
be
prejudicial
used
to
against the others.
Mr. Smith, who may not even be who Haley meant in that text. If Haley's not going to take a stand in order to explain what the six of us means, I think admitting that would be unfairly prejudicial to the other people. That's just my position.
State, I would respond.
Well, I think a couple things. I think Your Honor can instruct that this statement of Haley goes to Mr. Haley as an admission on behalf of Mr. Haley and not to the co-defendants. If the issue is the number six, or, okay.
I think you dealt with it. If the court will limit instruction to Haley, if you admit it, that's an admission asked to Haley and not any other party. Mr. Argument, I agree. Is that right, Mr. Argument?
All right, if the proper foundation is laid, then the court would
Ooh,
give that instruction.
sorry.
The court will give the instruction that there's, that be limited to the area of the author of that statement. But again, that would be dependent on the proper foundation being laid to
Hold on, y'all. I'm trying to get this back up.
allow for that statement to be in any other matter.
I believe there were some oral motions and
Now they want to be separate. They was the 6 Scorpion unit deadly enforcers by any means necessary. Now they want to be separated.
These attorneys are very well versed in civil litigation because they're part of it.
Now, I don't want to be with him.
Relevance, to the-
No, that don't mean me.
The proceeding that's before the court. Now, obviously, if there's witnesses that are given depositions in civil proceedings, I'm not seeking to limit their impeachment, like, I understand they may be impeached by prior statements they gave in civil proceedings. But the fact that there's a civil proceeding pending and what its status is.
A civil procedure pending. They butts in trouble.
That's more criminal issues before the court.
Have you heard? Are we going, are you gonna make it like that, or, Mary's gotta go first?
No, just one.
This happens.
All right, so we'll go ahead and just establish our order now, so Mr. Perry. Yeah, as it relates to that.
They were partners in crime, police crime, and mayhem.
At the court.
Now they want to be separate.
Particular point in time, prove from us what's going on in a civil case, could possibly go to bias, go to motive to testify a certain way. None of those issues right now have been fleshed out, and I think that to at least make that motion, or to grant that motion at this point, would be premature. We will receive this information, well, I received it.
They was the six musketeers before.
The day there, but I didn't know the emails, at the time, I guess they didn't send. So that was the first time we saw it. It doesn't go in particular law that says that it's innately illegal to go into. There's nothing that shows how the probative value is outweighed by prejudicial effect, to mention what's going on in a particular civil suit. You bring the right witness that has a motive, pecuniary motive in the case to testify a certain way, then I think that we should have the ability to cross-examine and confront that witness based off of that information. So at this time, as it relates to a motion in limine regarding, I think that that's inappropriate.
Your Honor, if I were to make reference to the civil proceeding, it would be something along the lines of, you recall giving testimony in another, in a related case, not say in the civil proceeding or anything like that. But there are things that are in there.
This man was not oh my God, this is just horrible.
Prior inconsistent statements, things of that nature. I would do everything that I could to not bring up the fact that there is a civil proceeding, and I think it can be done. However, if the witness is not understanding some of the things that I'm referring to, I may have to get closer to the edge of there being a civil proceeding. So that's our concern.
Judge, I want to be real clear that what Mr. Perry said is what my position is on this, not what Mr. Leffler said. Why are we dancing around such a huge issue of a $550 million lawsuit against the city of Memphis?
Did he say 550 million?
That we believe the investigation by the TBI and the DA's office was corrupted from the start. And we will have evidence that Mr. Crump's office, plaintiff lawyer, directed Mr. Mulroy, Mr. Hagerman, and Ms. Headley to take, for lack of a better word, a deposition of Preston Hemphill. And it didn't have one thing to do with Tyre Nichols. It had to do with the Scorpion team pulling black people over, roughing them up. It was at the direction of the plaintiff lawyer writing to Steve Moore saying, hey, we'd really appreciate it if you could ask these questions. So they called Lee Gerald, and they called Mr. Hemphill in. Mr. Hemphill had a cooperation agreement. So he comes in thinking it's going to be a proffer, and he sits there and basically is deposed, and it's transcribed, and that transcript has been provided to Ben Crump's office. And do we think for 1 minute that that type of influence by a plaintiff lawyer might affect what the TBI agents are out there doing, what the TBI agents coordinate with the DA's office to do?
So now it's Crump's fault.
It's not a fair investigation of these officers. It was one-sided, and that civil litigation will come in that way.
Well, I think though.
I think the video.
Acknowledge that there may be certain circumstances and situations in which the civil case may be relevant, but as far as the civil case just being out there, and it's not relevant to anything that we have going on, there may be certain situations and instances where impeachment may be at issue, bias or motive to lie may be able to be presented, but we're not going to try this little case over here. And so as far as all of the other things that are just plainly part of that suit, we're going to leave over there. What I would suggest, and my position is outside of impeachment, outside of bias or motive or something along those lines, then it has no relevance to this matter. Now, if as the proof is coming up, you all discover something or believe something has occurred which now expands that relevance, then we can approach and we can discuss and make a determination at that time. But I want to go into it with the understanding that we are not going to go into the civil matter unless it's for those purposes of impeachment or bias or motive or things of that sort. Again, if as we go through that proof, if you all feel some door has been opened and that we need to go through it, then we can have a jury out hearing and we can discuss that and make that determination. But where we stand now, the court's just going to limit the questions for the purposes of impeachment or bias or motive or things of that nature.
I go out of order for my list here because this seems to be a natural sort of progression. Filed a motion to eliminate with regard to the mention of the federal trial or any of the verdicts in the federal trial. I suggest that when we're referring to the federal trial during impeachment, that the attorneys call that at a prior hearing in the matter, if needed.
Impeachment?
A prior hearing in which these prosecutors weren't present, something like that if needed, to explain. Again, not trying to keep it out for impeachment. If these witnesses testify differently in federal court, understand that they can and will be impeached by their testimony. But the fact there was a federal criminal trial with regard to these defendants and whatever the results of that federal criminal trial were, I believe are entirely irrelevant to the criminal proceedings here.
They were found guilty.
To paint a complete picture, lying at a deposition is somewhat different than lying before a federally impaneled jury who's looking you eye to eye and you give an inconsistent statement. So that said, I don't know how to dance around that issue. Now, as far as me saying that we prevailed on the civil rights case or things like that, I can understand how the court's position on that would be. But I want to look this witness directly in the eye. If he takes the stand, he's given two inconsistent statements already. I'm thinking about the witness that they're going to call later today. One of them is directly opposite of the other one. One is before people that he's not sworn to, that he's just doing it to keep his job possible. The other before a federally sworn and impaneled jury. That makes a huge difference. And if he's willing to give an inconsistency there, then this jury needs to know that. Now, I don't, like I said, once again, to paint a picture about what the verdict would have been and things like that, I don't plan to do anything along those lines. But I do want to be abundantly clear. It's less than fair, and we're going to get into this argument, I think, on one of the motions regarding our ability to cross-examine regarding how much time they're facing, for instance. Well, if I tell a story in federal court because I'm facing a life sentence, which, by the way, the judge across the street had in our home, and we now know that that's going to be reversed for sure, because the federal 6th Circuit has ruled that you cannot hinder our ability to ask those questions. Well, later today, they're going to ask this court to do the same thing in a few moments. So we want to be able, I want to be able on behalf of me to say, hey, when you were facing a jury across the street, you said X, Y, Z, if it's inconsistent with what was said previously. And I think it's only fair that we be able to draw that picture and to try to sterilize it as if it happened in some back, office room space or what have you, is a lot different than being able to give it the full gravity of what it is. They're the ones bringing this case. They had priority. They indicted us first. We could have been trying it. It wouldn't have been an issue. But once you try a case with issues that are so parallel, then that's something that we face the burden of what we're saying. I think two of the motions that I'm joining Oral Tippins in indicate it's a double jeopardy argument that's out here regarding this case. They are wanting their cake and to eat it too by saying, hey, witness, if you're inconsistent, they won't know that you're inconsistent before another jury. That's less than fair to us because that tampers down that fire, and that shouldn't happen, Your Honor.
Before you respond, let me just go ahead and get the other defense attorneys a chance.
I think that sums up our position as well.
All right, Mr. Gamaki.
Second here sums it up well.
All right, sorry.
If the reference needs to be prior to hearing of the jury present, then that's fine. That's not,
I can understand that part of it.
but getting into particulars of the federal trial or the fact that there was a federal criminal trial against these defendants and there was a federal criminal trial.
They screwed up big time.
Prior hearing of the jury present,
Civilly,
I think that
federally.
being disingenuous, that we're just calling it a hearing in front of the jury. It's a trial.
And statewide.
And I think that it being a federal trial does not somehow
Minimize.
put into jeopardy or any kind of painting of the jury. I think that it paints an accurate picture of what was going on. Now, obviously, again, with regard to the verdicts and outcomes and things of that sort, there's not going to be any mention of that. But I think that not calling it what it was is not an appropriate manner of handling it. I think that we can call a federal trial. It was an impaneled jury, and I guess leave it at that. There's not a need necessarily to go much further into just calling it what it was, and we can just leave out as far as any verdicts and those things. We'll leave those things out. All right, next issue.
I'll go back to what Mr. Perry just mentioned. This, I guess, sort of has two components. It has to do with possible sentencing exposure. I think it's taken for granted, but I'll go ahead and make this, on the record that there shouldn't be any mention of the possible sentences or what these charges carry in terms of number of years or anything like that. That's entirely improper under Tennessee law. So that's the first half of this motion. The second is we do expect Desmond Mills to testify. As counsel knows, he's entered into a memorandum of understanding that's a written memorandum in which he agrees to plead guilty to the federal charges or have been guilty to the federal charges, and he agrees to plead guilty to state charges. He agrees that his truth should be taken, the prosecutors in federal court believe that his truth should be taken into consideration at his sentencing, that his sentencing will be set by a federal judge, that after his sentencing in federal court and his pleas in state court, that whatever state sentence he receives, it will be served at the same time as his federal sentence, and that he'll serve that sentence in federal prison. Obviously, all that's fair game, the memorandum of understanding.
So he's not gonna go to state prison
and could be
for testifying against them.
Could go to bias or motive or whatever else. This issue, the second half of this issue is litigated in federal court, as Mr. Perry mentioned, about what counsel was allowed to say and not allowed to say on both ends of the equation. They were allowed to ask whether or not Mr. Mills expected to receive, and Mr. Perry called it by its formal name, a 5K1 in federal court that would allow a federal judge to depart from their
Rest in
advisory
peace,
guidelines,
Tyre Nichols. Full justice for you.
They were not allowed to ask Mr. Mills if a federal judge could theoretically only give him probation on the case. At the same time, the state, U.S. government, was not allowed to bring out the fact that he was facing in excess of 20 years incarceration at the top end. So the question was, do you have this memorandum of understanding? Do you expect the truth to be taken in consideration with regard to your sentence? Do you hope the federal judge or the United States government recommends a downward departure at the time of sentencing?
but they were not able to get into either the low end, which theoretically I guess would be probation, or the top end, which would be in excess of 20 years incarceration in federal prison. I think that's the appropriate tack to take with regard to Mr. Mills. Obviously, bias, impeachment, we acknowledge. The memorandum of understanding goes to that. The idea that he expects or hopes for consideration if he testifies truthfully goes to that. The fact that the federal judge will determine his sentence goes to that. The fact that he hopes the federal judge will take into account his truthfulness goes to that. But as far as number of years and things like that, I don't think that's appropriate for this jury to hear.
All right, fair. Your Honor, across the street, we were forced to play a silly game during our examination of Mr. Mills. You're facing a lot of time, correct? You're facing a whole lot of time, correct? Instead of being able to say,
Please hit the like button.
the way that you're indicted, you're facing 3 possible life sentences. That is the way that I've always been able to ask questions. That is the way that the Court of Appeals subsequently, in the case of the way that our questioning was done by the judge prosecutor.
Please hit the like button.
The way that we were somewhat tied in that case to questioning like that not only gives a false notion to the jury, it gives a misconstrued and confusing question to the jury. Because if I ask that question, you're facing a lot of time. To be candid, Your Honor, if Your Honor gives me 10 days for contempt to John Key Perry Jr., that's a lot of time. If you give me a life sentence, that's a whole lot of time. And so to be able for jurors to say that they can dissect that and come up with some kind of a view of what that bias would be, because I might not lie about it, if I'm facing 10 days in jail. I might tell the whole truth and nothing but the truth. But if I'm facing a life sentence and a Department of Justice attorney is banging it on the table saying, this is how you saw it, this is what happened, is it not? I might be inclined to change my story about how it really happened to how the Department of Justice might want me to say it happened. That is the difference in context, Your Honor. And out of fairness, we should be able to, and I asked the court, and I know that it would be persuasive authority and not
They trying hard, ain't they?
because of the small amount of time that we were given.
But I guess that's what they paid to do.
That if you're inclined to look at it in the government's way, that at least pull that Sixth Circuit case, because the discussion is spot on with what we're doing right now. Trying to hinder our ability under the confrontation clause to fully examine the witness. We should be able to ask this question from top to bottom about why you are biased. And to ask these silly semantics about, how much time you're facing theoretically versus being able to say you are avoiding possibly X amount of years is the way that question should be allowed. In that case, what spills it out verbatim. What was the side on that? It's yours for me, Taylor. I don't know, Mr. Stanley, you had it.
Judge, it is now 1:27 after 4th, 1008. It's Sixth Circuit of February of this year. I'd offer the court a copy, except I have a lot of highlighting and notes.
No problem. All right, Mr. Stanley, do you have an additional argument?
Yes, Your Honor. Let me start with a couple of things. First, we received notice by email yesterday that the state intended to have address the court on motions in limine. Point out that there's a scheduling order in this court that required motions in limine to be filed on March 28th, which Mr. Haley complied with, and response is April 14th. So the defense is a little handicapped in the day before trial, the afternoon before trial, learning about these motions. I'd also suggest that the state's argument about the ruling in the federal court on this identical issue has some relevance for this court. It has no more relevance to this court's ruling in Mr. Haley's opinion than the verdict in the federal case has on the verdict in this case.
And I would agree with that. I mentioned the ruling in terms of way to explain the issue. I am not suggesting that the federal court ruling in any way finds Your Honor or should be considered some sort of legal precedent for Your Honor to consider.
And it's a confrontation clause issue, Your Honor. So it's a constitutional issue. In addition to the Sixth Circuit's Taylor case, I would cite to this court the Tennessee Supreme Court in State versus Sales, that's SAYLES, 49 Southwest 3rd, 275. It's the Tennessee Supreme Court in 2001. And essentially the law is that defendants have obviously a constitutional right to confront and impeach witnesses, and that impeachment, proper impeachment, includes demonstrating bias or promises of leniency. The court can put some limitations on, but the limitations have to allow the jury to have sufficient information to understand the potential bias or leniency that, in this case specifically, Desmond Mills.
We're waiting for them to come back from lunch.
Evaluate his testimony. And here, Mr. Mills pled guilty in federal court to a civil rights violation resulting in death. And based upon his conviction, he faced life imprisonment. That's the statutory maximum. And of course, there's no parole over in federal court. His federal plea agreement, in exchange for his cooperation, although statutorily he faced life, the federal prosecution agreed to recommend no more than 15 years imprisonment for him. So it is a significant benefit and promise of leniency.
Yeah, but it stopped y'all from lying. Well, it stopped them from lying
More than 15 years.
and covering up.
They recommend less. On the same day that he pled guilty pursuant to that plea agreement in federal court, he came over and appeared in front of Your Honor where his case
He
was
beat them
settled
to it.
pursuant to memorandum of understanding that he has entered with this DA's office. And essentially,
Please support
he
the
is
platform.
indicted on 7 counts over here, including a Class A felony, second-degree murder, where he's faced with a sentence of 15 to 60 years, and essentially he gets a pass. Under this memorandum of understanding, he will plead guilty after he is sentenced in federal court. He will plead guilty over here to something that allows this court to sentence him to the same sentence he received in federal court, which will be served concurrent with his federal sentence and will be served in the Federal Bureau of Prisons. In other words, based on his cooperation, this DA's office has essentially promised him that he will receive 0 minutes punishment in state court in addition to the federal punishment. And it is critical for this jury to evaluate his credibility, for them to know the exact amount of leniency. In the Supreme Court of Tennessee stated in the Sales case, I'll give a brief quote, "A defendant has the right to examine witnesses to impeach their credibility or to establish that the witnesses are biased. This includes the right to examine a witness regarding any promises of leniency, promises to help the witness, or other favorable treatment." Without this jury knowing what Mr. Mills faced based upon his conviction, or he faced in his court, and what recommendations of leniency he has received in exchange for his testimony, this jury will be unable to properly assess the credibility of his testimony, his motive for testifying, and any potential bias.
Mr. Sam, before you sit down,
Good.
if we start examining what Mr. Mills' his exposure is over in federal court, aren't we then also opening the door to what the other defendant's exposure is over in federal court, which, obviously that's one of the, as far as the case law with regard to defendants and what kind of time they could be facing, that's always been something that the jury's not been privy to, not been involved in. And so would we not, by saying this is what one of the co-defendants was charged with, then now opening the door of saying what the defendants could be exposed to as well?
Certainly, we will not in federal court, because Mr. Mills and Emmett Murda, two of the defendants who are not on trial, are the only two who have been convicted of civil rights violation resulting in death.
Right, but we're not getting into what the convictions and what the verdicts were. We're not getting into what the outcome of the federal court is. All the jury is going to know is that these individuals were in a federal trial, because that's what you guys wanted in your other motion, to be able to say that there was a federal trial. And then we're going to be talking about one of the people that was charged with this group not having that exposure of a life sentence. What I want to make sure
Hi, Patrick.
is that we are not wanting one, as was said before, not wanting the cake and eat it too. That if the door is open with regard to what the exposure is, we can't come in after the fact and then want to try to limit the understanding of the defendants are faced with a similar exposure. And I'm not sure how the case law would accept that. So I just wanted to see if you had a position as far as that.
Judge, my position is, on behalf of Mr. Haley, we have no intent of talking about his sentencing exposure. If a jury makes an equation based upon and reaches a conclusion in their hotel room or in their deliberations room about what he is facing if he's convicted, I can't control that. Where I think the case law makes very clear is that if the state, when the state puts a cooperating witness on, that in order to properly evaluate his bias and his promises of leniency, that counsel, should they choose, and believe me, I will choose, to examine him regarding the exact benefit that he anticipates receiving. And he has, frankly, avoided...
Okay, I just double checked to see if they have resumed, and they have not.
Cooperating and testifying. And without the jury knowing that that's what he has avoided, it is my position that the jury does not have sufficient information, as state and United States Supreme Court have said, sufficient information to evaluate his credibility based upon
Please hit the like
normal,
button.
Impeachment for bias.
All right, Mr. Demott.
I will adopt what Mr. Steen, whoever that is on Mr. Leffer's phone, I will adopt what Mr. Perry, Mr. Steen said just then, and I will go to your question that you've been following up with Mr. Steen. What about the other defendants? I would say that, one, you could take care of that by way of a limiting instruction, because it really just goes to Mills' credibility, the benefit of the bargain of him coming to cooperate. Or, number two, not give a limiting instruction, and the defendant, Justice Smith, would take his chances on the jury concluding that he's facing an equal amount of time, without getting into the issue that Justice Smith was acquitted of all civil rights charges. In other words, I would be willing to take that risk of them taking that lead. Or you can give a limiting instruction. But I adopt Mr. Perry and Mr. Steen's argument.
All right, Mr. Hager, do you have a response? All right, Mr. Perry.
And just brief, I want to make sure to emphasize the fact that Mr. Mills' agreement is a continuing cooperation agreement.
Hey, Lady JJ.
With the district court. In other words, he can't take the stand and retreat from the position that he shared over across the street, or he stands in violation of that agreement potentially, even in this forum, because he has not been sentenced yet in the federal case. He's incentivized. If I'm his attorney in the federal case, I'm definitely going to bring up the fact that not only has he testified here back in September, but he also testified in the Shelby County criminal court in April and May. We feel that his
Full justice for Tyre Nichols.
And that does make it a huge incentive.
Crooked cops do exist.
And I know the court did just much for federal workers out there, so that's a continuing agreement though. So that incentive for bias is still potentially there.
All right, the court's going to take that one under advisement with all the case law that's been presented on this before that witness testifies. The court will give its ruling on that decision. Was it intended that this information was going to be used in opening statements?
I didn't necessarily go too deep into it. I will say something regarding measures of the motive and bias of different witnesses, but not specifics regarding exposure. I will be giving Haley's opening, and I can afford this.
Other than they have a cooperating witness, that the more they cooperate, the better they do on sentencing. I'm not getting into life sentence and all that.
Okay, so then I will go ahead and give a formal decision on that prior to that witness's testimony. Just reserve that and not delve into the details until that time.
In the first half of that, will you also find that any mention of state sentences and possible sentences in state court is irrelevant?
Correct. And, I mean, I think the case law's been pretty clear as far as referencing these sentences, potential sentences, and with regard to the defendants in the state court. So we'll go ahead and exclude those.
We're down to the last two.
Let me check and see if they've returned from lunch. Bear with me.
I can't remember if the filings themselves were under seal or not, but I don't think they were. There was a motion by at least one of the defense counsels, maybe two of the defense counsels, having to do with selective prosecution, arguing that these defendants were somehow charged because of their race. There were some filings under seal that asked for certain records. Your Honor found no evidence of that at all. The state would make a motion that any sort of reference to selective prosecution or race being the reason these defendants were charged is disallowed.
Race.
The motion were filed because under Tennessee state law, it's required as a predicate if we're going to make that argument. And as of right now, that argument has not necessarily met the predicate that the court has ruled. We realize the court ruled as it relates to what the court had an opportunity to look at in camera. The only issue that I have with it being a motion in limine is that potentially the witnesses that can establish whether or not that was an issue, and it might take a stand And I don't want that to be something that perhaps if we want to address the court at that particular time or approach and say, Your Honor, based off of the answers to certain questions, we believe that we should be able to delve into this. And so I would ask that the court reserve ruling as it relates to an indemnity motion. Particularly, I think that on one of the potential witnesses is the person who was not in fact indicted. And because of that, we feel that the court should be able to make that determination at the appropriate time. But to stop it as of right now, and to be clear, in my opening, I don't plan on joining.
He coming up
anything along those lines.
in advance on what he may have to use.
Perhaps could be ruled on down the road in the trial.
All of them black though. I don't know how he gon'
Mr. Haley's position is that subject to the state opening a door along those lines, based on the court's pre-trial ruling, that should be so.
I will say that what you got in camera, because I trust Mr. Haggard so much, I just assume everything is given to you. If you make that ruling pre-trial.
he trusts the DA. They not gonna pull up nothing about race. They all black. I mean, what?
Trial shakes out, just hold it under advisement, because we're not going to be bringing opening argument or anything like that. But if something happens, we would like to revisit it.
Yeah, I think the court has already given a ruling on that, and irregardless of what the ruling is, if there was something that opened the door that changed the landscape, then we could revisit it at that point. So we'll go forward.
Ooh, they be trying, don't they?
The court's previous ruling that where it stands now, there'll be no mention of it unless a situation were to occur to open that door. And if it does at that point, we can see all that motion and renew that objection, and we can have a hearing if necessary. All right, next matter.
And this is a final one. This is something that's also litigated in federal court, but I think I can make this real short. As Your Honor explained to the jury when we picked the jury, people assume that Your Honor's read the whole file and all this, and we know that's not how these proceedings. Your Honor does not have access to arbitration purposefully, so you can make fair and unbiased decisions. This incident occurs, and we can call it different things, but there is a traffic stop of Mr. Nichols. There is an initial encounter there at his car. Mr. Nichols then runs away. One of these defendants that's on trial was present at the traffic stop. None of the other two defendants were not present at the traffic stop. The two defendants, Mr. Dean and Mr. Smith, respond to the radio that we have somebody running who's been tased and resisted. They encounter Mr. Nichols along with Mr. Mills in a neighborhood just a tenth of a mile from the scene of the car stop. What happens, and there's poll camera and body cam video of it. After all that is over with, Mr. Nichols' car is searched. In his car, they find a small amount of marijuana, along with a even smaller, I don't know what the phrase, like a residue sort of amount of a mushroom. I can't pronounce the scientific name, psilocybin, I think. A very small amount of the psilocybin with a small amount of marijuana. They also find in his car some documents. I'm going to call those maybe like identification documents. I can't remember exactly if it's a driver's license, but it's definitely like
Hey, Granny's prayer.
and other people's or other person or two's name. If it's a credit card or if it's an ID or whatever it is, it is. All this is found after Tyre Nichols is beaten. None of these officers have any knowledge of what's found in his car at the time. It hadn't even been found in his car at the time. So our motion is to stop any reference to the contents of Mr. Nichols' car as it has no relevance to the mental state of these defendants or to the charges that are before the court.
Mr. Barrett?
Yes, Your Honor. We have a case where, if you look at the very beginning of Emmett Martin turning on his blue
They should be back live in a minute.
We've been at 385 and Riverdale, and he comes to a stop at Ross and Range. That's two
0.3 miles away from that initial blue light. I think that the context, to a certain extent, speaks to the res justi of Mr. Nichols. Your Honor, it's different than the standard case for several reasons. This is, to make these type of apprehensions is the job of these men that are on trial. Whether or not they caused the death of Mr. Nichols in the way that the state is saying, or in any way kidnapped him or had official misconduct, etc., those are things that the jury should be able to make the assessment of and at the end of the day rule on. But in order to do that, they should.
They detained him illegally, moved him, and that's why they got kidnapping charges.
But equally, what's in the minds of a person who has, and I think that it was danced around a little bit, but there was several identification and several credit cards that were stolen. And those are the things that at least go to the res justi of why this person, in essence, avoided being stopped on 3 different occasions. He avoided it in the car, ignored the blue lights and siren, ignored it on the first scene when he breaks away. He goes to another scene.
Sir, he could have threw that out the window, right?
At that second scene, and then is finally found at a third scene by Mr. Bean, and when he makes eye contact, he runs. So those are things that should be a complete picture. Now, I understand if the court says you shouldn't want to go into, personal belongings or this, that, or the other. No intent on that. But if, in any case, there is res justi, if it was the converse and Mr. Hagerman was prosecuting a person for whatever reason, that criminal defendant, based off of whatever it is that he had in his vehicle, that becomes a subject of why that person might be fleeing. In any case, and in this particular case, res justi is central to it. Now, I think that if it was something that they really wanted to argue and fight about, we should have argued this back if it was filed at the time that the deadlines were, and we could develop those arguments with a number of, with cases in case law. But here, it's clear that if you got what he didn't want to mention to the court a second ago, stolen credit cards and stolen IDs, that would give anybody a motive to try to avoid being apprehended. And that is a central issue. We're not only standing here asking whether or not what was in the minds of these individuals, but it surely should be a question out of fairness, what's going on in Mr. Nichols' mind at that time, and that question mark is somewhat answered from our perspective. Now, if the jury says, hey, I don't think that matters, then that's their purview. They can weigh the facts, that's what they do. But in order to give some kind of a misconceived notion that he's just driving home and just says, hey, you know what, I'm going to do Dukes of Hazzard, I'm going to keep on riding away from blue lights, that's disingenuous. And it's just not fair. And we're asking that if the court says you want to avoid the things that are irrelevant in the car, that might just paint them in a bad light, we understand that. But specifically the items of credit cards and things that are along those natures that are found in the car, we think that, and I think it's clear they're stolen. I don't think they're going to stand up and say, well, they weren't stolen. But as long as we can establish the fact that these are stolen identifications, credit cards, etc., I think that it's open game, young.
Just so that you said, one of the same things was disposing of things?
Yes, in 6705, 6705 Ross Ridge, it becomes clear that he is, yeah.
All right, I'll go ahead, Mr. Shanklin.
Judge, to be clear, it's not the entire contents of the car that we are trying to get in. It is psilocybin mushroom that was seized, and it is identifications of 2 individuals that was stolen. It wasn't just somebody else's ID and credit cards. We can establish that it was stolen. As a matter of fact, for one of the IDs and several of the debit and credit cards, there is a police report from the day that it was stolen. The owners of these IDs and credit and debit cards will testify that they were stolen and they have no connection to Tyre Nichols, and there is no way that he had authority to be possessing these things. The introduction of them for this jury's consideration is important because it tends to negate, if the jury so chooses.
How long did they get for lunch?
Some statements that Mr. Nichols made that they will hear at Ross and Raines on the video. He says, I didn't do anything, while he's in possession of controlled substances and stolen property. He also says, I'm just trying to go home. The video makes clear he is not directly going home, and this video at 6705 Ross Ridge, he is seen slinking around parked cars and hiding, disposing of things and hiding from passing cars, one of them being one of the Scorpion unit cars that drove by. So in addition to tending to negate, from Mr. Haley's perspective, for the jury to do what it wants with those statements, it also goes to the lawfulness of his detention. In addition to the lawful traffic stop and traffic violations that Mr. Nichols chose to make 2.2 or
Hit the like button. Please.
where he was blue lighted, it goes to the lawfulness of the detention.
Can y'all hear?
After he's fled 3 times at Castlegate and Bear Creek. Mr. Haley's charge.
Can y'all hear?
Kidnapping, and his detention was lawful, not only from his flight, not only, but from his possession of stolen property and controlled substances. And finally,
Hello?
there has
Can
been
y'all hear?
suggestion, that the officers who made statements about Mr. Haley's strength and ability to resist and avoid being handcuffed were lies. And his continued flight and his continued failure to cooperate and resist may well be explained in part by the possession of stolen property and controlled substance as he is pulled over by the police.
Judge, I don't have a lot more to add other than maybe a different take on it. This is probably one of the clearest examples of race gesti you're ever going to run across. Because as soon as Mr. Nichols ran from first blue light, then ran from range and Ross, then hit at 6705, and then ran from B, the question is, why is Nichols running? Of course, the jury's going to be able to determine, oh, he's scared of all police officers, he just wants to go home, or he wants to get away from that car. And that's race gesti, the complete picture. Now, this court can limit some of the, we're not getting into the other predilections that are in that car. If we're looking at items of crime, Mr. Hyder might say small amount of psilocybin, but it's a Schedule I narcotic. It's that he has to get away from that car. If he gets away from that car, gets away from the cops, then he doesn't get linked to it. Now, so instead of talking in ambiguous terms about the credit cards and debit cards, not only were there police reports regarding these specific credit cards, debit cards, photo IDs that were found in Tyre Nichols' car. It was part of a break-in that occurred on October 31st, the night of October 31st, Halloween, and the early morning hours of November 1st, just a few months prior to this, okay? But what's interesting is the person who pled guilty to breaking in these cars and stealing the very items that are found in Tyre Nichols' car was captured November 4th. So I think it's more than fair to say, no, wait a minute now. How does this fella who admittedly broke into these cars and stole these credit cards and debit cards get those in Tyre Nichols' car within that short 2 or 3 day period? But then further, Your Honor, this court needs to take into account that when the TBI and the district attorney gathers up these stolen credit cards, let's just say Martin Zumach's American Express card is in the bottom of that car. Instead of calling Martin Zumach up and saying, we have a police report here that says you lost your American Express card, we may have found it. Instead of doing that, they gave, I almost said returned, they gave Zumach's credit card to a third party. And we should be able to explore that as it relates to how this investigation unraveled. All they were doing was focusing on convicting these people instead of looking into what was going on. So this is the clearest example of race gesti
Goalposts, moving the
Mr.
goalposts.
Nichols had every reason to run, hide, fight, flail, to get away from that car. And so, Your Honor, to limit us, and by the way, I would hate if we keep referencing rulings of federal court and complicate error by trying to mimic it over here. The reason race gesti, I might as well say it, the reason race gesti argument did not win the day in federal court is because there is civil rights case law on point that says once something is found later, it's not relevant because it's the police officer's state of mind at the time they came into contact with the defendant, whether or not they used unreasonable force. I didn't like the order of the court as it relates to race gesti, but that's not what we have in this case. We have common law murder. We have kidnapping. We have every reason to look at the victim and what he had going on in his mind at the time he's fighting, fleeing, and getting away with these police officers and dumping stuff on the side of the road. So I believe to paint the picture is fair. If you want to limit the instructions, that we're not going to use it to, bash Tyre Nichols, I surely understand that. But to then hide the ball from this jury when they have to figure out what's in Mr. Nichols' mind as well as what's in these cops' mind, I think it'd be unfair. Your Honor.
Okay, Mercedes, respond.
This jury has to find the mens rea of these defendants. Mr. Nichols is not on trial. These items were found after all of this was over. I don't see the relevance of it with regard to...
He not on trial. He's not on trial.
Listening to the arguments that's been presented, obviously these items don't necessarily go to the mens rea of the defendants, but the court thinks that those items, not allowing those items to be discussed, paints an incomplete picture of what may have been occurring that evening. Obviously, the mens rea, the focal point is the mens rea of the defendant.
That is not the reason why they beat him to death.
Circumstances that could have contributed to the events that led up to ultimately what fed into the mens rea of the officer. The court finds those to be relevant. Now, with the caveat that obviously Mr. Nichols is not on trial here. And so the purpose or the basis on which the court will allow for that information to come in is for that limited basis of being able to paint a complete picture. But we're not going to go deep into the criminality of what was going on, but it's simply that these things were discovered and can be inferred that this could be argued that this may have contributed to the behavior that led up and to the interaction that ultimately took place between Mr. Nichols and these defendants. So the court will allow those with just the admonishment to the defense attorneys that we need to make sure we stay on course and not digress from with the additions of these facts. Anything else from outside?
I think that's all the motion one is,
All right.
Oh, they tried, didn't they?
You probably just for housekeeping purposes, I think we can discuss.
Oh.
I filed a dual sovereignty motion, and I believe Mr. Stingle did the same. I don't want to just make that a throwaway motion because it's not a throwaway motion. But at the same time, I think to save it for potential appeal, it has to be ruled upon by the court prior to beginning trial.
All right. And,
I'll have PM or Tennis in both, join both,
all right. With being said, now I have a motion that's been filed on behalf of Mr. Stingle. All right, Mr. Leffler, do y'all want to give a brief argument with regard to this motion?
Judge, very briefly, we need a ruling. The Supreme Court, specifically Justice Gorsuch, in a dissent, said that there are limits to dual sovereignty. In that case, it was a dissent. In that case, they reaffirmed the dual sovereignty doctrine, but he said that there are limits. That case didn't reach the limit. This motion says that this case reaches the limit, and the reason it reaches it is because, and I attached some text messages between the district attorney, Mr. Mogul, and his January 2023 pre-indictment contacts with the heads of the Department of Justice Civil Rights Division as they were coordinating two prosecutions. And I would suggest that that explicit cooperation means that this case has reached the limit, and double jeopardy. Jeopardy does attach based upon the federal trial, and this case should be dismissed.
I don't know if I heard you. Do you have both my?
Home. It's where we do the things we love with the people we love. So what if we live tomorrow in the same place as we did yesterday? With help, we can. Home instead for a better what's next.
Did you know
Hopefully
that all
they
the
coming
veggies
back.
on Freddy's premium steak burgers are chopped, sliced, and shredded fresh in-house?
The prosecution.
Let me double check and see if they back.
Constitute double jeopardy. Cooperation or even coordination or talking or sharing or whatever between a United States attorney and a district attorney with regard to the case. It's not even the issue. The court, even in the dissent, states that if one of the prosecutions is basically a, quote, sham prosecution, not a real prosecution, but just some sort of strategic prosecution to bolster the other, then, again, the dissent would have a problem with that. Obviously, we're in full-blown prosecution. Here we are. There's no evidence that one of these prosecutions has been a total sham that would even meet the standards of, again, the dissent. As a majority of the Supreme Court upheld the doctrine of dual sovereignty.
Judge, the only thing I would add is we have not received the state's written response that Mr. Hagman just referenced.
Well, with regard to the motion, the dual sovereignty doctrine obviously has been in place for some time. Obviously, I haven't seen anything looking over case law on that would prevent the government or the state from being able to discuss, cooperate, coordinate, or anything of that nature, that would somehow negate the ability to pursue those charges. Looking at these cases, obviously the defendants are charged both thoroughly and in court. The charges, though, differ in some.
They are gearing up to start back up. Please hit the like button. They are beginning to return back and resuming the trial. Day one, Tyre Nichols, beaten to death by the Scorpion Unit, special unit put together by the Chief C.J. Davis, who also put a similar team together in Atlanta, the Red Dogs, Mean Dogs, Atomic Dog, and no, I'm just playing, that was dismantled due to wrongful. Someone, I think they went into the wrong person's house. A 80-something-year-old lady, and she was unalived. Yeah. Excessive force, abuse, mishandling, bad copying, bad policing. Waiting for them to return from lunch. Day one, Tyre Nichols, state trial. They've had the federal. They were found guilty. And there is also a civil case pending. And one of the Scorpion unit officers has already pled guilty and is a witness against his partners. Oh, wow. My goodness. I guess I can play some music, huh?
Attention shoppers, want to spend less? Go to Aldi. They're number one.
Excuse me. Oh, Lord, I wish they'd come on. What are we waiting? Let me see. And I mean, they are taking their own sweet time, baby.
We all know that violent crime is the biggest issue facing our city, but this week may have been one of the worst in recent memory. Tonight, Fox 13 is breaking down the shootings and the numbers to show why.
This is what's going on in the city right now.
Thomas, let's take you through some of these cases. Late this afternoon, Fox 13 learned the 2 people shot and killed yesterday near Booker T. Washington High School were students at the school. The shootings around 3 o'clock yesterday afternoon forced the school into lockdown and added to an already growing list of violent crime in Memphis over this past week.
And that violence continued overnight. Memphis police responded to 2 separate shootings in Orange Mound. Investigators say one man was critically injured on Saratoga Avenue, another killed on Ethel Street.
At least 6 people were shot, 4 killed in Frazier since Tuesday night.
And a deadly mass shooting at a candlelight vigil Saturday night.
And
left
they had a
one man
mass
dead
shooting
and
last
4 others
night.
injured, including a 14-year-old boy. Memphis police say it's time for the violence to end.
Free up your weekend and your budget with True Green. No one makes it easier or more affordable.
Time for the violence to end.
My career being on the job, has been a lot of violence here in Memphis. You know, we need to curtail it.
Enough is enough in this city. It's time that the citizens know that this is not going to be tolerated.
We need your help. Community, we need your help. In order for us to solve this crime, the Memphis Police Department need you.
Yes. Fox 13 Investigates went through our archives for the last 7 days. Since last Friday night through this morning, we found these 26 shootings reported in Memphis and Shelby County.
It represents 36 people shot. 15 of those people
They had a
killed
press conference. I'm
in
trying to
1
find the
week's
press
time.
conference
And it
while
does
we
not
wait
include
on
other
them
reports of shootings where no victims were
to
found.
start back up.
Fox 13 continues our live team coverage of this issue tonight. Fox 13's Daniel Wilkerson is in South Memphis right now, getting reaction from a mentor to one of the students killed yesterday.
But first, Fox 13's Martin Staunton joins us live in Raleigh. Martin, you were there earlier to really take the concerns of the community to the mayor and the police chief.
Yes, I was, Darcy, and Chief C.J. Davis says that her department has investigated 28 homicides in April, and there are still 5 days left to go in this month. And she and both the mayor talked about the role that children are playing in all of this.
As I think about the last couple of weeks, we've seen far too much violence in our city. And it has been completely unacceptable.
Completely.
To see young people losing their lives senselessly.
In just the past week, a seemingly endless string of violence. At least 15 people killed and 20 more hurt in more than 24 shootings in Memphis and Shelby County. Many of the victims and alleged perpetrators
Are teenagers.
These young people is somebody's son, it's somebody's nephew, somebody's cousin, it's some OG in the neighborhood who knows these young folks that need to be speaking some life into them and changing the course of their trajectory.
Police Chief C.J. Davis said it's hard for most people to wrap their minds around the amount of gun violence right now.
We're appealing to the community to help us. Parents, get your children. That was the C.J. Davis that came out of me. Get your children. If you want life and if you love your children, help them stay alive by paying attention to them, just like the mayor said. Either they will die to gun violence or they will end their lives in jail.
Mayor Paul Young shared an idea of something simple parents can do to help.
For the parents, the guardians, if you see a young person walking out of your household with a hoodie on when it's hot outside, with a backpack on, and it's not a school day, you need to ask some questions. You need to check the backpack. You doing that check is going to save their life.
And the mayor, chief, and other leaders here did more than just talk about the violence. They offered one possible solution. Coming up at 6, we're going to take a closer look at a bill that could soon become law that could actually help cut down on the businesses that give crime a place to fester. And you at home, could be compensated. We'll share those details coming up. Darcy?
That is Fox 13's Martin Staunton reporting live tonight. Thank you so much, Martin.
When they put the rest in peace sign behind his name and his picture. And all I could think about when he was a little boy coming in the barbershop, he used to come here all the time.
A South Memphis barber says this one hurts. That's Carlos Miles. He says from infancy, he mentored a 17-year-old who was shot to death yesterday near the intersection of South Lauderdale and Mississippi, very near Booker T. Washington High School. That teen, one of the 2 students shot and killed near the school yesterday. Let's go to Fox 13's Daniel Wilkerson in South Memphis Live in search of solutions. Daniel, Miles is far more than a barber here. He's looked up to as an authority figure in that area.
Yeah, Daryl, you know it. The people at home know it. The barbershop has been long looked at as the nucleus of neighborhoods in inner city areas. This barbershop is no different. You can see someone there getting their hair cut. Oftentimes, people in that chair, be they older or young people, they will confide and listen to their barbers. Well, Carlos Miles told me that he had mentored that teen shot and killed yesterday. He says the 17-year-old's father just got out of the hospital yesterday. Miles shared this video of him cutting the boy's hair a while back. Now, Miles and community activist Frank Gotti say after this rash of shootings, we first will have to turn to God. He says that's the number one solution. Second, they say everyone is going to have to put skin in the game and act as mentors did back in the old days. They say teens want attention, and if the bad actors are offering to give them attention, that's who they'll turn to.
Let me tell you about a 13, 14, 15-year-old. The only thing they want is a hug. They be want to know somebody looking out for them. If we just go up to them sometimes. Encourage them.
Like for real, sometimes you gotta just let them kids, we'll feed them, then we'll let them go play basketball, run outside, do whatever they want to do for like about 2 hours. But then we were getting closer to them, and they were getting comfortable with us.
Frank Gotti.
You know what I'm saying? As a child get comfortable with you, he gonna learn how to talk to you. He gonna want to come and talk to you about his problem. You know what I'm saying? And when he feel like he in a sticky situation,
This is not the one I wanted. It's taking them too long to come back.
Carlos Miles, he uses his barbershop as a place to talk to youngsters. He says they trust him. But again, he says he needs help. Know him. He runs the Put the Guns Down organization in the Greenlaw area.
Attentive as we go through this process. We left off with the defense opening statements. Mr. Stengel, you ready to proceed, sir?
I am, Your Honor. Thank you.
Good afternoon. Mike Stengel, and along with Mr. Steve Leffler, it's our privilege to represent Demetrius Haley. Choices, ladies and gentlemen. If you want a theme for this trial, I'd suggest to you it's choices. Demetrius Haley chose to become a Memphis police officer. He entered the MPD Training Academy in August 2020 at the height of COVID, graduated in January of 2021. From there, like all graduates, he rode in a two-man car with what they call a field training officer, a senior officer who helps new graduates bridge the gap between the classroom and enforcing the law on the streets of Memphis. He successfully completed that field training program, became a patrolman, and in October of 2022, he was assigned to the Scorpion team. Scorpion Team 1. Scorpion was different, ladies and gentlemen. as Mr. Hagerman said, they didn't have a precinct to patrol. They dressed differently. The Scorpion Unit was a street crime abatement team created by the police department's command staff. And it was their job to go, they were assigned, not a precinct, not a regular area to patrol, but based upon crime data that the command staff reviewed, they would send each Scorpion team, there were 3 different teams, to a particular area for a few weeks at a time. The highest crime, most dangerous areas of Memphis. And they were to saturate the area. Now they looked different and they dressed different, they had different cars. They were undercover cars. You've seen some of the video. Those 2 Dodge Chargers were Scorpion team cars. They were undercover. Unlike regular Memphis patrol cars, there was no in-car video on these undercover cars. They also had interior blue lights, not on top, like patrol cars. They dressed differently. They were in all black. They wore sweatshirts.
So they didn't have the regular
they had
lights on top of the car.
Police written on them, all in reflective. But they also wore masks, what I call watch caps. They had different radios. They had their own radio channel that was encrypted.
They had masks.
Only the Scorpion team members could hear the radio traffic, unless, of course, they switched to the precinct channel or switched over to reach the dispatcher. And their job, designed by the command staff, was to go and saturate these high crime areas and make traffic stops. The law is very clear, and these officers were trained at the academy, that the United States Supreme Court has said, as long as you see a traffic violation, it is okay to make a traffic stop, even if you have an ulterior motive. And the command staff gave the Scorpion team members an ulterior motive. They needed a traffic stop. They needed a traffic violation to make a valid stop. But they weren't making a stop to write a ticket. They were looking for people with warrants. They were looking for guns. They were looking for gun switches. And they were looking for drugs. They were there to suppress crime. They'll also learn, as all policemen are trained and know, there are 2 types of traffic stops. An unknown stop, which might be me being blue lighted and pulled over driving home from court today. Or a high-risk stop. High-risk stop may be stopping somebody who you know has just carjacked and shot somebody and is driving the carjacked car. There is no such thing as a low-level traffic stop because policing is dangerous. You never know what you're going to encounter. If I'm an unknown traffic stop getting pulled over, I may have a gun waiting for the officer to approach. So it's either unknown or high risk. January 7th, 2023. About 8:20 p.m. at an intersection on Riverdale near Quince Road. You'll learn these streets over the next week to 2 weeks. Just north of I-385, Emmett Martin, a member of Scorpion Team 1, gets on the radio and says he's got a speeding blue Nissan Sentra that's just blown a light. He's going to pull it over. Demetrius Haley, on duty with him on Scorpion Team 1, is right in the area and acknowledges he'll assist with the traffic stop. Another Scorpion Team member, whose name you've heard, Preston Hemphill, is also right there. He acknowledges he'll assist with the traffic stop. driving down Riverdale, which has a 45-mile-an-hour speed limit. Martin turns on his blue lights, turns on his siren, and the blue Nissan Sentra chooses not to pull over. When choosing not to pull over, he chooses to commit at least 2 more traffic violations you'll hear of. He's still speeding, and at least twice he switches lanes without turning his signal, putting another car in between him and Martin. Martin, Haley, and Hemphill are following the blue Nissan Sentra down Riverdale in excess of 45 miles an hour. The blue Nissan Sentra turns right on East Rains, and East Rains is also 45-mile-an-hour zone. There's a little crest in the hill before they get to Ross. The proof will show that Preston Hemphill got up to 64 miles an hour in this 45-mile-an-hour zone and was falling behind. He lost the other cars as they crested that hill. But he crests the hill, and right there at the intersection of Ross and Rains, the light is red. The blue Nissan Sentra is in the left turn lane. Demetrius Haley's car is on the left side, the driver's side, parked. Emmett Martin's car is angled at the front passenger side. Hemphill, and you'll see his body-worn camera, you'll see virtually the entire stop, because you see Demetrius Haley leave his car, you see Emmett Martin leave his car, and of course the camera shows Hemphill leaving his car. The driver's choice not to stop, and you'll hear that it was obvious that the driver was avoiding pulling over when blue lighted with the siren. Martin announced on the radio that in police talk, the driver was getting little on him, disappearing, running, fleeing by car. That in and of itself, according to the officer's training and procedures, changes what would have been a routine unknown traffic stop to elevate the risk somewhat. Makes sense. People pull over for lights and sirens. When the Nissan Sentra stopped right by the cars that he had been driving away from, that again increased all of the officers' awareness and concern, because it was unusual behavior. Very unusual. Consistent with his training, Demetrius Haley got out of his car and used, as he was trained, what they call verbal judo. He loudly and profanely, you'll hear it, ordered the driver out of the car. The driver chose not to get out of the car. Haley approached, opened the door, and he's continuing to give commands. Commands are being given. The driver, Haley approaches the door, opens it, and the driver leans away from him. Haley moves up the Memphis Police Department's use of force continuum that you started learning a little bit about last week. And he uses soft hands. He reaches in to get the driver out. The driver pulls away from him. Haley reaches back in, pulls him out, and it was Demetrius Haley.
Please hit the like button.
Haley on the driver's side, getting the driver out. I think Mr. Hagerman misspoke when he said it was Haley, or it was Martin who pulled him out of the car. But it'll become clear as you look at all of the video and listen to the testimony. Haley got him out of the driver's seat using the soft hands technique and put him in the A-frame of the car, between the body of the car and the open driver's door, to get his hands behind his back, handcuff and detain him for this increased risk traffic stop. The driver chose not to comply and not to allow his hands to be cuffed, and indeed spun around on Haley in the A-frame with Emmett Martin and Preston Hemphill there. At that moment, once the driver has chosen that, Emmett Martin announces, "Let go my gun."
Oh,
now,
wow.
danger and risk has dramatically increased. All officers are trained to keep track of your gun. Never let a suspect get your gun. With that announcement, the driver is taken to the ground,
Hey,
where
Byron.
he still is not compliant. He still chooses to blade himself rather than follow the commands to lay flat. He is still resisting having his arms put behind his back, and Demetrius Haley uses his pepper spray. They're down on the ground, unable to control the driver at this point, and in an attempt to pepper spray the driver, Haley gets himself. At that moment, the driver chooses to continue not to comply. He gets up and he gets away from all three officers. As he is running, you'll see he's initially running towards an open car door on a vehicle that's running. Officer Preston Hemphill shoots his taser and frankly misses. It does not connect. The driver is off running southbound on Ross. Haley and Hemphill chase him. The chase is very short, a couple hundred yards at most, before Hemphill falls behind. The driver's frankly faster than Hemphill. Haley is overcome by the pepper spray. You'll learn and see, the proof will show how debilitating pepper spray is. Hemphill tells dispatch, "We've got one running. Let everybody know to be on the lookout." Gives a general description of the guy and says he's been pepper sprayed and tased. Haley is virtually blind from the pepper spray. As he and Hemphill are getting back to the cars half a block or so away, Haley is stopped and needs Hemphill's help to cross the street. He's virtually blind. For the next 7.5 minutes, Haley, with Hemphill's help, is at Ross and Rand's with the police cars, literally trying to pry his eyes open, to have water dumped on him, to try and flush out the pepper spray. Proof will also show that there's no real remedy for pepper spray. It's trying to flush your eyes with water, it's getting air at it, and time. 7.5 minutes.
Hey, Vicky.
Hemphill is repeatedly dumping water on Haley's face.
Awesome.
And eyes as he's trying to recover.
Thank
During
you.
those 7.5 minutes, they're still hearing the police radio and dispatch. And Haley learns that other Scorpion officers, a two-man car first, driven by Mills with Bean in the passenger seat, see the suspect at Ross and Castlegate, and he's taken off on them. And they are running after him on foot. So Haley learns through the radio that the suspect has run again, a third flight. And also, while he is still trying to recover at Ross and Raines, it comes over the radio from Justin Smith that they've caught the suspect. They need more cars because he's fighting. After 7.5 minutes, there's been enough recovery, enough water. Hearing his fellow officers need help, Haley puts his tactical vest back on, gets in the car, and heads to Bear Creek and Castlegate. Arriving there, the times will mean more over the next several days, but he arrives there at 8:36 and 15 seconds. When he arrives, he knows this is the suspect. He knows he's fled 3 times. He knows he's gotten away from...
For those of us with service animals, preparation is key.
Sorry.
Ensure your buddy always has...
Let's go.
Mills and Bean. He knows that Justin Smith has called for more cars because he's fighting. As he arrives, the driver and a couple of officers are down towards the ground. The driver has a handcuff on his left wrist, nothing on his right wrist. He is not detained, and the police training is that single cuffed wrist is a weapon, a potential weapon, very dangerous.
Just like them
Chooses
boots
to
that he
follow
had on his
training
feet
using now the
when he kicked him in the head.
a single leg strike, a kick, to his upper arm, a muscle pressure point closed area of the body, in an attempt to get that arm released so that the other officers on the ground with him can get him handcuffed and detained. It works, and within seconds, the driver is handcuffed and detained. Seconds after that, consistent with his training, Haley gets on the radio and tells dispatch, we need an ambulance. The suspect has been pepper sprayed, tased, and everything, is his exact phrasing. You're going to hear medical proof. You'll hear from the medical examiner and at least one forensic pathologist. The proof's going to be virtually identical. Cause of death goes back to blunt force trauma to the head,
That kick,
which led to a stroke or stroke.
the beating with the baton,
Cardiac arrest, and over the next 3
excessive
days,
beating.
organ failure and death of the driver at St. Francis Hospital. All of the force and all of the trauma is on video, and you're going to see it. You have to piece a little bit together because some parts are on different officers' body-worn cameras, and some on the Skycop cameras. But they all have a timestamp on them, and the body-worn cameras all have an identical camera number that I call an axon number It's an Axon camera system, AXON, and then a lengthy number. So you'll know whose body-worn camera you're watching at the time you're watching. At Ross and Raines, Demetrius Haley used soft hands at this high-risk traffic stop to get him out of the car. He used pepper spray and helped to take her to the ground after Martin announced, "Let go my gun." The driver took off.
Which was not true. That's why he took a plea.
Or attempted to use his taser there at Ross and Raines. At Castlegate and Bear Creek, you'll see that the driver was tackled. I believe it was Officer Bean that was the first one to reach him and tackle him. Bean and Smith were the first two there. Mills was the third one there. Mills used pepper spray 3 times and the asp baton on the same right arm. Martin, you've seen once, kicked him twice in the head and punched him 5 times in the head and face. All before Demetrius Haley arrived. Proof and common sense show that you can't intervene in something you weren't there for and didn't know about.
Sure you can. You can come in at the end and get you a kick or two. A punch or two.
Had a duty to render aid, and he did once the suspect was detained. He virtually immediately called for an ambulance. While this is going on, back at Ross and Raines, Hemphill is still with the cars. And of course, he has notified the dispatch that medical response is needed because of the use of pepper spray and a taser. Again, that's Memphis Police Department protocol procedural. Immediately after Demetrius Haley left Ross and Raines, I say immediately, virtually immediately, within a minute or so, the fire department arrived at Ross and Raines in response to dispatch's request because of Hemphill's call. It was engine 55 and there were 2 EMTs, emergency medical technicians, riding on it. Robert Long and Jamichael Sandridge. They got out with their bags and they approached Hemphill there at Ross and Raines. And while they were there, they learned that they were called out not to treat an officer who had been pepper sprayed, but to treat the suspect who had been pepper sprayed, been tased, had been fighting with the officers, and had fled, and was at a different location several blocks away.
Had he been hit yet, sir? Had he been kicked and stomped
They
yet?
also learned that the suspect would not be brought back to Ross and Raines for treatment, but they were to go down Ross to Castlegate. They did. Once they got to Ross and Castlegate, and you'll learn Bear Creek is a small cove cul-de-sac, a block up from Ross, a block up Castlegate from Ross. There were so many police cars at that intersection and along Castlegate that the fire engine couldn't get up there. So Long and Sandridge got off, they took their blue trauma bag, walked up. They were directed to the suspect who was handcuffed, and seated up against one of those two undercover cars you saw. And they also overheard officers saying at the scene of Castlegate and Bear Creek that they believed that the suspect was on something. While those EMTs were there, they, along with law enforcement, got the suspect's wallet out and learned that his name was Mr. Tyre Nichols. He was nothing to Demetrius Haley or any other Memphis police officer other than the driver of that blue Nissan Sentra until that point.
Yeah, y'all thought he was Marcus Thorne.
When Long and Sandridge arrived and were directed to Mr. Nichols, he was alert, he was oriented, he was answering questions. His speech was slightly slurred. He told them he was 29 years old. He admitted that he had been drinking some alcohol. He sort of ignored the question about drug use. He neither admitted nor denied drug use. He just really didn't respond. He didn't complain of pain. He didn't say anything about what had happened. He repeatedly said, "I want to be uncuffed," and stood up. Those EMTs spent the next 14 minutes standing and observing Mr. Nichols. They also, can't remember if I said, they checked and his pupils were pinpoint, which to them was indicative of the suspected drug use. Because of that, EMT Long called for an ambulance. He and Sandridge stood and observed Mr. Tyre Nichols for roughly 14 minutes. And you'll see them. No vital signs taken, although their paperwork said they were. After that 14-minute mark, an officer, off camera, but you hear the voice. Now, believe that it's Justin Smith, but you'll make your own determination. But an officer says something, "Hey, are you okay?" directed at Mr. Nichols. EMT Long is there, and he notices a change in Mr. Nichols' condition.
I'm sure you did.
Performs a sternal rub, which is basically a knuckle in the breastbone, to see how responsive he is. And Mr. Nichols responds to that. At that same time, the ambulance, Unit 28, arrives. It is staffed by another EMT, Jalen Jones, and a paramedic by the name of Jesse Guy. The paramedic has more education and is able to provide a higher level of care and perform procedures and administer drugs that an EMT can. Mr. Guy takes over the care, immediately gives him Narcan, intranasal Narcan, in an attempt to counteract what may be an overdose.
Oh, wow,
By
I'm
this
out of
time,
juice.
Mr. Nichols has gone from alert and oriented to responsive to pain to unresponsive. Paramedic starts an IV, more Narcan is given, he's loaded onto a stretcher, put in the ambulance, and the ambulance is off to St. Francis Hospital. Virtually when he back doors of the ambulance are closed, and EMT Long from Engine 55 ends up driving the ambulance in the back with Mr. Nichols and treating him. Paramedic Jesse Gott, other two EMTs, Jermichael Sandridge and Jalen Jones, who had arrived in the ambulance. He is treated, he goes into cardiac arrest, and gets CPR, various drugs, and is transported to St. Francis Hospital, where the care is transferred to the emergency room. Ladies and gentlemen, the facts here are tragic.
Very.
They're tragic.
Very.
Demetrius Haley was present for portions of this. But a tragedy does not mean a homicide occurred. And Demetrius Haley's presence during portions of this tragedy does not mean he engaged in criminal conduct. The proof is going to show that Demetrius Haley chose to engage in policing, which can get ugly and dangerous and dirty. And he followed his training that night. The state has brought murder, kidnapping, assault, oppression, and misconduct charges against Demetrius Haley. I'm not going to spend time on the elements, but I want to talk very, very briefly about the state's burden. We all know it's beyond a reasonable doubt. It is the highest burden in our legal system. It's not an insurmountable burden, but it is the highest burden. It is such a high burden that it is higher than the burden the state would have to meet if this was a case where it was trying to take custody of a child from his or her parent. That's how high beyond a reasonable doubt is. Demetrius, the state will not be able to prove the elements of this murder, kidnapping, assault, oppression, or misconduct charges beyond a reasonable doubt against Demetrius Haley. He thanks you for the time you've already given and for your paying attention to the proof. Listen to the proof. Learn these intersections in Memphis. Look at the times on the videos. Look at who did what and who was where, and hold the state to this high, high burden of beyond a reasonable doubt. Thank you for your time and attention.
Yes, sir. I happen to know we have a second grade teacher in amongst us. So when the kids come back from lunch and you stick them in a hot classroom, what happens? There you go. So, Judge, with Your Honor's permission, could they stand up just stretch a moment? Because we.
If anyone needs to step, stand up, or if you need a drink or need a rest, you all are welcome to let us know. We will take that rest. Otherwise, we'll go ahead and proceed.
I just don't want you falling asleep during the time. All right, I've done this 32 years. And in 32 years of trial practice, I've never read my opening statement ever. But this is probably going to be my last jury trial, and so I want to make sure I don't miss any points.
Oh, he gonna retire. Oh, he retiring after this.
I have the pleasure of representing Mr. Justin Smith. Justin, could you stand? This trial started with an indictment. And as it's been explained to you, the indictment is giving notice to defendants what the charges are against them. And you've heard what those charges are, ranging all the way from secondary murder, all the way down to official oppression, kidnapping, aggravated assault. All right?
Wow, this gonna be
What
his
you may or may
last
not know,
one.
is it may or may not make a difference to you, is the indictment for murder actually was filed and then publicized within days of Tyre Nichols' death. The indictment came before the autopsy was ever gotten back on Tyre Nichols. The indictment occurred before the toxicology reports on Tyre Nichols ever came back. Then we went through that, as criminal defendants, you need to go through the process of indictment, turning yourself in, et cetera, and then we just go on the process of discovery. So there's a lot of things that we know in our files that you don't know yet because the state has to give us what's called discovery. Okay, and so from that discovery is what we piece together our defense, and it's what the district attorney uses to prosecute. Now, Mr. Hagerman said a very common theme that we heard in Memphis a lot for the last over 2 years. Justice for Tyre. Justice for Tyre.
Absolutely.
Tyre died, which, by the way, is a tragedy. It's tragic whenever anything that God created dies before its time. It's tragedy. Everyone was screaming and yelling, justice for Tyre. And these indictments came down targeting 5 police officers. And about the only thing they had in common were they were on the Scorpion team and that they were at Bear Creek and Castlegate that night. You've heard from the lawyers about someone named Emmett Martin. Emmett Martin's not here. The reason Emmett Martin's not here is he's already pled guilty to killing Tyre Nichols.
He's already been part of the Scorpion unit that.
Desmond Mills has also pled guilty to causing the death of Tyre Nichols. He's the one with the baton. I'm going to baton the fuck out of you. Give me your hands. Give me your hands. That's that guy. He's
Hey,
already
so
pled
blessed.
guilty to causing the death of Tyre Nichols. What you may or may not know is
There was a unit.
they're awaiting sentencing. Their sentencing, some of it's going to depend not only on the crime that they pled guilty to, but it's also going to depend on their testimony here and how favorable or how cooperative they are with the state. Don't think for 1 minute, if somebody's looking at life in prison, they won't come in here and point the finger and say whatever they can say so they can get favorable recommendations from the government to reduce their sentence. Okay, those 2 guys aren't here. The guy who punched Tyre Nichols, I think 5 times. And you're also going to hear from the pathologist that says that there are 5 distinct tears in the brain, coincidental, that killed Tyre.
Lord.
What happens is, or what happened is his brain started shutting down from the injury. It then affects your central nervous system, and his went into heart failure. Okay. During that period of time while they're waiting on the ambulance, only 1 cop is monitoring Tyre's respiration rate. And you'll hear him, Mr. Sting was right, you'll hear him on tape saying to these EMTs, who I'd be willing to bet we're all going to walk away from this saying those EMTs were the most incompetent people in the whole world. Because Justin Smith said either 3 or 4 times, hey, do you have the baggy thing to put on him? It's a rebreather to give someone oxygen. A cop is telling the EMTs, do you have the baggy thing to put on him? You'll see and you'll hear Justin Smith saying, his O2's getting low. Where's your green bag? You'll hear that phrase, green bag. The green bag is the bag that has the oxygen canister in it that EMT Long was supposed to have brought with him. By the way, before I forget, there's some confusion about EMTs and ambulances, okay? In Memphis, what happens is they will dispatch a fire truck first, and on that fire truck are EMTs. So that's who first arrives, okay? Then, if the medical care is higher or needed higher, that's when dispatch will then send an ambulance. And you'll hear proof that ambulances are in very short supply in Memphis. So what they'll do is, in order to span that gap, they send a
Short
fire truck
supply
first.
on ambulance.
Now, I think Mr. Stingle misspoke.
Short supply on
Hip
police.
Hill is not who called for Justin Smith, and you'll hear it at 13 minutes and 15 seconds on the dispatch tape. You'll hear that tape. The whole interaction starts at 9 minutes. That's when they're over there fighting at Rawson Range Road and doing all that, okay? And the call goes out saying, hey, we have a black male suspect running southbound Ross Road who's been tased and sprayed. Every cop who's going to come in here and testify will say, when you hear that, that means he's going to fight. If someone's been tased and sprayed and he's running, he's going to fight. And so when an officer calls for assistance because of a fight, you come. That's what Mr. Perry mentioned about how they let back to those suspects go so they can respond to help, okay? But listen on the dispatch tape. At 13 minutes and 15 seconds, it's Justin Smith who comes up.
It's Senator Kirsten Gillibrand, your DSCC chair, and I need your help immediately. Democrats and independents across...
Apparently, hey, go ahead and roll MFD now if chemical agent has been used. Because they know they're going to decontaminate it. Okay. That was Justin who called before they ever even caught Tyre Nichols. So at the end of this, don't tell me that Justin Smith was not concerned about the medical care of an unknown suspect who had not been searched, who had been fighting with the police, who had been tased and sprayed, that Justin Smith was responding to. Now, Justin Smith, if anything, is a horrible navigator. So he rolls up to Rains and Ross Road where Hemphill is standing, and this is what Mr. Perry was talking about. You'll see on the body cam, you'll see Justin pull up, stop for like 2 seconds. He looks at Hemphill and says, which way do you go? Hemphill, you'll see him, he's a very young, very chubby, chubbier than me, white guy. He points and says, that way. Off Justin goes. So Justin goes into the neighborhood because his experience tells him if you don't catch somebody pretty soon and set up a perimeter, you're not going to get them. And if he's been sprayed and if he's been tased, by the way, this after the fact business about the taser didn't work, nobody knew that then. Okay? You'll see Tyre Nichols run away from the taser, taking his coat off. I don't even think Tyre Nichols didn't know that he had been tased. But if you don't get medical to check someone out, you can find them later in a bush dead from an asthma attack, shock, whatever, heart attack, whatever. So Justin calls dispatch. Can we set a perimeter up so we can get this guy? Okay? And as Justin's sitting at a stop sign, trying to figure out where he's going, he looks up and he sees Tyre Nichols running, and Tadarius Bean chasing after him down a dark street. We people who are not cops, that don't work the 6 p.m. shift, 6 p.m. to 2 a.m. shift, in the second most dangerous city in the United States, don't understand what it is to run down this dark street after a suspect who has now run from the cops 3 times, and he's unsearched. You will hear proof Justin Smith in a short 4-year, 5-year period on OCU, that's organized crime, which is the umbrella of this work, made over 1,000 felony arrests. Think about that. That's almost 1 a day. That's how dangerous Memphis is. We are
very dangerous.
The 5th most, this is FBI statistics, 5th most dangerous city in the world for murders. And Tadarius Bean is chasing this man down a dark street and tackles him. Justin's sitting in his car. He sees this happen. So Justin makes the choice. We hear about choices. Justin makes the choice to get out of his car and help Tadarius get this guy in handcuffs. Okay? Now, I may or may not misquote Justin. If so, please forgive me. The tapes will be my guardrails, okay? But the first thing Justin and Tadarius say is, bro, give me your hands. Give me your fucking hands. Man, just give me your hands. And they want to take issue with the fact that they had his hands. Okay? But I want to tell you something. And every cop that's going to testify will tell you that as old as I am, if a cop grabs my hands and I don't release my arms, it'll take 3 cops or more to keep those arms behind my back. So as they're screaming, give me your hands, and they've got their hands on him, that's like, give me your hands so I can put them behind your back and handcuff them. Okay, that's what that means. They don't have to say, sir, could you please relax the deltoid muscle on your arm so I can take your arm and put it behind your back and safely handcuff you? No, give me your hands. Tyre must have known what it meant because he wasn't given those hands. Okay? Justin was able to get one handcuff on the left wrist of Tyre Nichols. You'll see this in the video, okay? So imagine that handcuff. By the way, these are the actual handcuffs that were used to arrest Tyre Nichols. Now imagine this on my left wrist. This has not been clasped onto the right hand yet. Those serrated teeth right there, I flipped that one time, that's it. And this police department trains their officers that if a suspect gets the cuffed hand away, you can use lethal force on them, shoot them. Now that's what they train. Now while this is going on, Mills, as Mr. Haggerty correctly
y'all hear that?
It's kind of a theme of this case.
They train to shoot and kill y'all.
He sprayed everybody in the group. He sprayed Nichols, he sprayed Bean, he sprayed Smith.
Based on snatching away from handcuffs.
OC spray, pepper spray. Much more powerful
Wow.
than Diggs or Patrick.
Again, wow.
And you'll see training videos on that. One shot, one squirt in the eye will shut you down. You're not going to see, you're not going to breathe. And remember, you're on a dark street with one handcuff.
Excuse me.
Justin wears glasses, you can see. His glasses were knocked off in the fight. He's got pepper spray, he's breathed it in. If people want to take issue with what Tadarius and Justin were doing, guess what Emmett Martin did, the one who pled guilty to killing him? Guess what Desmond Mills did, the one who pled guilty to killing him, when he sprayed it? Those two walked off and took a 1.5 minute break to get their breath back. You'll see all this on video. You got Mills over there breathing, snotting, spitting. You got Martin, who's like this big. Whoo, whoo. He breathes. Not Tadarius and Justin. They still got their hands on him, on Nichols, trying to get him. You'll see him bent over at 90 degrees. By the way, the white tennis shoes are Justin. Justin had blown his knee out the night before on another chase where he caught somebody. He wasn't even supposed to be at work.
Oh, he should have stayed at home.
His wife told him not
Ooh, I know he didn't stay at home.
He's been over. He also has they call it, sometimes we call it tactical vest, but it's a
Ooh, I know he didn't stay at home.
bulletproof vest has 2 reflective strips along the rib cage. So it's real easy to keep an eye on Justin during this whole occupation. Tadarius, about the same, a little bit bigger than Justin, he has a black hoodie on, so he looks like a cone head as he's wrestling with Tyre Nichols. These cops arrest violent felons every night. And every cop who come in here and testify will tell you that Tyre Nichols was the most difficult arrest they've ever made. He had superhuman strength. And I'll bet you right now you're asking the same question that everybody in the world was asking. Why did Tyre Nichols run from that first traffic stop with Emmett Martin, Demetrius Haley, and who else?
Because the cops was dressed like they were thugs. And like they was finna carjack or kill him. We see it every day in Memphis. They was dressed just like those assassins. That's why.
When Haley and them, these big men, put him on the ground, and he got up and ran away, why did he run away from that car? Why did he abandon his car? He's looking at a reckless driving charge. Whoop-de-doo in Memphis. You get a gold star in Memphis for that. Why did he run? Then you're going to see him just down the street on another skycop camera, not the one that Bear Creek casket, but another one. And you will see Tyre Nichols, the TBI agent, will come in here and testify.
Show y'all why.
Tyre's hiding
They just told y'all how they was dressed in special uniforms that looked just like the hood, the thugs on the streets.
Make sure it's gone on down there. He turns around and starts walking this way. Sure enough, 2 minutes later, Mills, who's not here, and Tadarius find Nichols walking nonchalantly through the front yard. Somebody else's house. Tadarius says, "Hey!" Boom, off he goes. That's that chase we're talking about. Down a dark street. Tadarius caught him. Okay? Now, do you remember
Let me find this picture.
about the definitions of second-degree murder? Unlawful, knowing, or intentional. And remember this phrase, reasonably certain. So, not reasonably expected, reasonably certain. When you hear about Justin Smith, and when you hear about Tadarius Bean doing what they did that night, there's no way. There's no way.
We start with the breaking news update.
Responsible for Emmett Martin. You will also hear proof that Emmett Martin was deranged. Emmett Martin was deranged. In fact, to some people, he had admitted being homicidal. Yet his Lieutenant Smith, put him out of the streets anyway. Cops have to rely
Photos have been released to the
surgical team that Keith Berry talked about. Gotta rely upon the other cops.
If they want to know why he ran, based on the
people
description
Memphis police investigators believe are responsible for the deaths of two
that they said the Scorpion unit was dressed,
Memphis Shelby County school
their
students.
uniform.
Take a good look here. These are from
let this be the reason, because they were dressed just like this. So you ask, why was he running? Because the Scorpion unit was dressed just like this. So what is the possibility that he thought that y'all were trying to rob him, kill him, carjack him? Yeah, because this is how they were dressed, per their attorneys. Judge look at like he already say 30. Okay, let plus size baddie, right?
No one could expect it, much less be reasonably certain, that Emmett Martin would come and crush the brain of Tyre Nichols. And before you take my word on it about what kind of person Justin Smith is, you will hear proof. Justin Smith never allowed another cop to ever abuse a suspect. You say, well, that's great, Zumach. Everybody would say that. You will hear direct proof that not 1 month before this, Justin Smith turned in a Scorpion cop, slapping a handcuffed suspect. Just slapping. What Emmett Martin did was a heck of a lot more than slapping somebody. Justin Smith was proud to be a police officer. You will hear proof. That's all he ever wanted to be. He wanted to be a cop since he was 10 years old when his mama was being abused and a Milliken cop came to her assistance. He didn't have 2 nickels rubbed together. He went to college, and he only applied for 1 job out of college. That's the NPD. You will hear Justin Smith's former bosses, I'm talking about brass, people are really in charge. They're not worried about what MPD thinks about him coming in here and testifying. They're going to come in and say he was a kind and compassionate cop who protected suspects and he protected other officers. You will hear Preston Hemphill describe Justin Smith as kind and gentle. Yet he's standing here, having lost his career, lost his reputation, standing charged with second-degree murder. So if you hear a little bit of frustration in my voice about that, that's what it is. So we're going to watch a bunch of videos, we're going to hear a bunch of audio, we're going to hear a bunch of foul language, And at the end, I think good things will happen for Justin. Because
Good things gonna happen for Tyre Nichols and his family.
indicting cops, that's a big thing nowadays. No matter what the politicians want to done to all these cops, it's your word. You will be the final word whether or not Justin Smith broke the law. And I'm confident.
Yes.
Yes, Your Honor. State calls RowVaughn Wells.
Hold on. Mm. Whew.
May I speak to Mr. Hagerman real quick? I may be able to take care of it. Yes, we are going to call for rule. However, I believe I'm going to permit one exception to that.
Wow. This is crazy, y'all. This is oof. Oof. I don't recognize the one with the glasses. Who is he? Bing. Which one is he with the glasses? I'll go Smith. Haley. Bing.
We may need
There go the mother. There go the mother, Tyre Nichols' mama.
I'll shorten that to
Oh, wow. Oh. Oh.
You solemnly swear or affirm that the testimony you give today will be the truth and nothing but the truth to help you God.
She finna testify how they lied to her about her son. Oh, wow. Oh, my God. Bless her heart, Lord. Oh, my God.
Good afternoon, Ms. Wells. Good afternoon.
Oh, my God.
Will you introduce yourself to the ladies and gentlemen of the jury, please?
Hello, my name is RowVaughn Wells. I'm the mother of Tyre Nichols.
Oh,
Ms.
Jesus.
Wells, will
Bless
you
her.
spell your first and last name for the court reporter and for the jury, please?
My first name is ROW. V is in Victor. AUGHN is in Nancy. Last name Wells. WELLS.
Oh,
Ms.
my
Wells, you
Lord.
mentioned you were the mother of Tyre Nichols.
Yeah, I already got tears in my eyes. Lord Jesus.
Yes.
Who is your husband?
Bless her,
Rodney
Lord.
Wells.
And how long have you and Mr. Rodney been married?
It'll be 13 years in November.
You mentioned Tyre was your son. Do you have other children?
Yes.
Can you tell the jury about your other children? Their names.
Kiana Dixon is my oldest daughter. Michael Contreras is my oldest son. Lindsay Dupree is my middle son, and Tyree is my baby.
Lord.
Ms. Wells, are you a native Memphian?
No,
Can you tell the jury when you moved to Memphis?
I moved to Memphis in 2008, March of 2008.
And I want to draw your attention back to the time of January 2023. At that time, where were you living in Memphis?
At
6743 Castlegate Lane.
And who lived with you at 6743 Castlegate?
My husband and my son Tyre.
Where were you employed back at that time in January 2023?
First Horizon Bank.
Was Mr. Rodney Wells employed at that time?
Yes.
And where did he work?
At FedEx.
Was Tyre Nichols employed at that time?
Yes.
Where did he work?
At FedEx.
Did your husband and son work together at FedEx?
Yes.
I want to draw your attention specifically to the date of January 7th, 2023, a Saturday. Tell the jury what you remember about how that day started and specifically your interactions with Tyre that morning.
Well, when I woke up that morning, Tyre wasn't at home. He came in about 11:30 that morning. There was a co-worker that was teaching Ty how to drive the forklift. So Tyre would go in on Saturdays and they would, he would teach him how to do the forklift. Tyre, like I said, he came in about 11:30. We spoke briefly. He went and laid down. He got up about
Tell the jury what you remember about how that day started and specifically your interactions with Tyre that morning.
Well, when I woke up that morning, Tyre wasn't at home. He came in about 11:30 that morning. There was a co-worker that was teaching Ty how to drive the forklift. So Tyre would go in on Saturdays and they would, he would teach him how to do the forklift. Tyre, like I said, he came in about 11:30. We spoke briefly. He went and laid down. He got up about 2 o'clock or something like that. He took a shower, messed around the house. And about 3:30, he was on his way out the door.
And as he was on his way out, did you have a conversation with him before?
Food for dinner that night. He asked me what I was cooking. And he said, Mama, are you getting ready? Are you cooking some chicken? And I said, yes. And he said, well, how are you going to make it? And I said, well, I think I'm going to do sesame chicken today. And he just kind of rubbed his stomach. Okay. So about 3:30, he was on his way out the door. He hugged me and said, I'll see you later.
And did he enjoy your sesame chicken?
No, he never made it home to enjoy my sesame chicken.
Tell the jury what's the next thing you heard about Tyre that day.
Well, about 8:30. I say about 8:30-ish, 8:45, somewhere up in there. We got a knock at the door. My husband and I, we were getting ready to watch a basketball game. I was complaining about my stomach hurting earlier. So he decided to come in the room with me and watch the game. And we were just going to lay across the bed and watch the game. We got a knock at the door. Bang, 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 Memphis police. My husband went to the door. I heard a gentleman say, does Tyre Nichols live here? My husband, he paused a second, and then I came to the door, and I said, yes, Tyre lives here. I'm his mother. What's going on? They proceeded to tell me the police officer that was at the door, it was actually 2 police officers at the door. One proceeded to tell me that Tyre was arrested. And I asked them why he was arrested. And they said for DUI. DUI. That didn't sound right to me.
And tell the jury, why doesn't that make sense to you?
Because my son, he doesn't drink like that to have a DUI. We're not drinkers in our families. So Ty would barely drink a beer, or something. So it just didn't seem right to me. They proceeded to ask me, was he on drugs? Did he do any type of drugs? And I said, no, we don't do any type of drugs. Smoke a little marijuana. And I said, why? They said because he had all this wild strength and all this strength and everything, and they had to end up pepper spraying him and tasing him. And that still didn't sound right to me. And I made a statement. Well, if all of that happened, then somebody must have put something in his drink or something if they were saying all of this stuff happened. So the officer told me that they were going to be taking my son to the hospital. I asked him where my son was, and the officer said he was nearby. And I said, nearby? And they said they were going to take him to the hospital because he had been tased and pepper sprayed. I said, well, okay, what hospital is he going to? I need to go. The officer told me that I could not go because Ty was arrested. He proceeded to get some more information from us and everything, and then they left.
After those officers left, what did you do next?
After the officers left, I started kind of pacing the floor a little bit. I got my phone, and I started trying to call my son. He didn't answer. I told my husband, come on, let's go. Let's go find Ty. He took a little too long, and I had jumped in the truck, my SUV, and there was another police officer just sitting out there. So my husband came. We were going to take the route that we thought, Ty would come home. And because they were saying that they were taking him to the hospital, we just kind of assumed that it would be St. Francis because that's where normally they take, people. So as we got into our vehicle and we drove to Rains and Castlegate, we made a right on Rains. No, we made a right on Ross. I'm sorry. We made a right on Ross. We got down to Rains and Ross. And that's when we noticed Ty's car.
Now, that intersection at Ross and Rains where you see Ty's car, how far is that from your house, Ms. Wells?
Maybe a half a mile.
When you saw Ty's car there, what did you do?
We immediately pulled over, and I got out the car and I started speaking to the officer that was there. The officer asked me again. It was a different officer. He asked me again, was my son on any type of drugs or anything, because he just had all this strength and all this Hulk Hogan strength and everything, and they had to do all these things to him in order for him to arrest him. And I kept trying to find out why they were arresting him in the first place.
And did that officer you were speaking with at Ross and Rains answer that question for you?
Not really, no. I don't recall. He just said my son was pulled over for DUI and he ran from the police. I think that's what he said. I can't remember if he...
Did you come into contact with any other officers at that scene, or just one?
There was another officer there. They were gathering up the tape. He spoke to me, the officer did, and he handed me his card. After that, we left and went back to the house.
At that point, what is your plan? Are you waiting to hear more, or what were you doing during that time?
When I got back home, I called my daughter, because I was actually on the phone with my daughter prior to the police coming to the door. And I called to let her know, Ty's been arrested. And she said, what? And after I explained to her what was told to me, we were both kind of baffled about it. And I said, well, there's nothing I can do tonight, you know. I don't even know where he is. I'll just figure it out tomorrow, and I'll let you guys know what's going on.
What is the next thing you heard about or from Ty?
About 4 o'clock in the morning, I received a phone call from a doctor from St. Francis Hospital. The doctor asked me if I knew if my son was in the hospital. I said yes. I heard he got arrested and he was tased and pepper sprayed. The doctor said, no, ma'am, your son is sick. And I said, what do you mean he's sick?
Check what the doctor said other than some of the premise behind it, but she can't go into what the diagnostics are.
Your Honor, may we approach?
Three. For real, for you. I had a friendship though before all, because I seen Rainwater. I ain't cool with none of this. Rainwater was just saying in the interview that him and all of one was first.
What?
What he said, did you become extremely concerned about Ty's condition?
Oh, wow.
Nasal, intranasal.
I didn't have the volume up all the time.
And he just kind of bugged his stomach. Okay, so about 3:30, he was on his way out the door.
I didn't have the volume up all the time.
And said, I'll see you later.
And did he enjoy your sesame chicken?
No, he never made it home to enjoy my sesame chicken.
Tell the jury what's the next thing you heard about Tyre that day.
Well, about 8:30. I say about 8:30-ish, 8:45, somewhere up in there. We got a knock at the door. My husband and I, we were getting ready to watch a basketball game. I was complaining about my stomach hurting earlier. So he decided to come in the room with me and watch the game. We were just gonna lay across the bed and watch the game. We got a knock at the door, bang, 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 Memphis police. My husband went to the door. I heard a gentleman say, does Tyre Nichols live here? My husband, he paused a second, and then I came to the door, and I said, yes, Tyre lives here. I'm his mother. What's going on? They proceeded to tell me, the police officer that was at the door, it was actually 2 police officers at the door. One proceeded to tell me that Tyre was arrested. And I asked them why he was arrested. And they said for DUI. And DUI, that didn't sound right to me.
And tell the jury, why doesn't that make sense to you?
Because my son, he doesn't drink like that to have a DUI. We're not drinkers in our families, so Ty would barely drink a beer, or something. So it just didn't seem right to me. They proceeded to ask me, was he on drugs? Did he do any type of drugs? And I said, no, we don't do any type of drugs. Smoke a little marijuana. And I said, why? They said because he had all this wild strength and all this strength and everything, and they had to end up pepper spraying him and tasing him. And that still didn't sound right to me. And I made a statement. Well, if all of that happened, then somebody must have put something in his drink or something if they were saying all of this stuff happened. So the officer told me that they were going to be taking my son to the hospital. I asked him where my son was, and the officer said he was nearby. And I said, nearby? And they said they were going to take him to the hospital because he had been tased and pepper sprayed. I said, well, okay, what hospital is he going to? I need to go. The officer told me that I could not go because Ty was arrested. He proceeded to get some more information from us and everything, and then they left.
After those officers left, what did you do next?
After the officers left, I started kind of pacing the floor a little bit. I got my phone, and I started trying to call my son. He didn't answer. I told my husband, come on, let's go. Let's go find Ty. He took a little too long, and I had jumped in the truck, my SUV, and there was another police officer just sitting out there. So my husband came. We were going to take the route that we thought, Ty would come home. And because they were saying that they were taking him to the hospital, we just kind of assumed that it would be St. Francis because that's where normally they take, people. So as we got into our vehicle and we drove to Rains and Castlegate, we made a right on Rains. No, we made a right on Ross. I'm sorry. We made a right on Ross. We got down to Rains and Ross. And that's when we noticed Ty's car.
Now, that intersection at Ross and Rains where you see Ty's car, how far is that from your house, Miss Wells?
Maybe a half a mile.
When you saw Ty's car there, what did you do?
We immediately pulled over, and I got out the car and I started speaking to the officer that was there. The officer asked me again. It was a different officer. He asked me again, did my son was my son on any type of drugs or anything, because he just had all this strength and all this Hulk Hogan strength and everything, and they had to do all these things to him in order for them to arrest him. And I kept trying to find out why they were arresting him in the first place.
And did that officer you were speaking with at Ross and Raines answer that question for you?
Not really, no. I don't recall. He just said my son was pulled over for DUI and he ran from the police. I think that's what he said. I can't remember if he...
Did you come into contact with any other officers at that scene, or just one?
There was another officer there. They were gathering up the tape. He spoke to me, the officer did, and he handed me his card. After that, we left and went back to the house.
At that point, what is your plan? Are you waiting to hear more, or what were you doing during that time?
Well, when I got back home, I called my daughter, because I was actually on the phone with my daughter prior to the police coming to the door. And I called to let her know, Ty's been arrested. And she said, what? And after I explained to her what was told to me, we were both kind of baffled about it. And I said, well, there's nothing I can do tonight, I don't even know where he is. I'll just figure it out tomorrow, and I'll let you guys know what's going on.
What is the next thing you heard about or from Ty?
About 4 o'clock in the morning, I received a phone call from a doctor from St. Francis Hospital. The doctor asked me if I knew if my son was in the hospital. I said yes. I heard he got arrested and he was tased and pepper sprayed. The doctor said, no, ma'am, your son is sick. And I said, what do you mean he's sick?
Yeah, check what the doctor said other than some of the prints behind it. She can't go into what his diagnostics are.
Your Honor, may we approach?
Okay, so that other guy must have been a part of the attorney team. I knew I didn't recognize the guy with the glasses on. It's like, who is he? I think the mom did good.
What he said, did you become extremely concerned about Ty's condition?
Yes, very concerned. Until to the point where I called my cousin and I said, get over here right now. We need to get to the hospital and go see Ty.
And is that what you did?
Yes.
Who went to the hospital with you at that time?
My cousin Tony, she came over to meet us, and my husband and I.
What hospital was Ty at?
At St. Francis Hospital.
Tell the jury what happened when you walked into St. Francis.
As we were walking into St. Francis, there was another officer walking in. We were kind of going in the same direction, so I asked, you're working late tonight, huh? He said, yes. He said, I'm here to sit with a prisoner. And I said, well, is the prisoner's name Tyre Nichols? And he said, yes. And I said, well, that's my son. He said, oh, okay, well, follow me. So we all proceeded to walk to Ty's room.
Ms. Wells, I know this is going to be difficult, but I want you to explain for the jury when you went in Ty's room, what you saw, what Tyre looked like, what you saw, what you felt, what happened in that moment.
When I walked into the room and I saw my son, I immediately went over to him and I fell out on him because my son was beaten to a pulp. His head was the size of a watermelon. His nose was broken. His neck was split open from the swelling. He was bruised from head to toe. It was like they beat the shit out of him. That's what they did. They beat the shit out of my son and left him for dead. That's what they did.
And Ms. Wells, were there other officers in that hospital room when you walked in?
The doctor was there. There were some other officers in there. Once I saw my son and I basically passed out on him, basically. I just laid on him and just started crying. And I just burst out and said, what the fuck is going on here? This does not look like no pepper spray and no tasing. And a police officer took my husband and I out the room. My cousin stayed there and took us into another room. I want to say it was a sergeant or captain, I can't remember. We spoke briefly. And then next thing you know, all the Shelby County police and everybody was out the room. They said TBI had taken over the case. And all the police officers that were there were gone. And so it was just the TBI, the nurses, the doctor, and my husband and my cousin. We were in the room with my son.
When you saw your son, was he ever responsive to you that night?
No. Tyre was not responsive. He was on a breathing machine, and the machine was keeping him alive.
And did you know from the minute you walked in that room that night that your son was gone?
Yes. You couldn't. There's no way my son would have survived from that. He was already deceased, basically. I say they must keep him on those breathing machines for 72 hours. But my son was deceased.
Ms. Wells, several days after that, did you get a call like that from the hospital on January 10th informing you
They back.
of your son's passing?
Yes, I got a call a little after 2 by the same doctor, Charles. I want to say Charles. I can't remember. I meant to look. I can't remember.
Bless
He
the
said,
Lord.
Mrs. Wells? I said, yes. He said, this is Dr. from St. Francis Hospital. I said, yes. He said, I just called to tell you that I pronounced your son deceased at 1:41 p.m. And I just lost it. I dropped the phone and I lost it. 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 Because the first thing I had to do is try to figure out how I'm going to tell his siblings that their little brother is deceased. That was one of the hardest things that I ever had to do as a mother, is to explain to them. I called my daughter. When I explained it to her, I heard her falling down the stairs. She cracked her nose. And the fact that I'm from California, all my kids still live in California. So it was very difficult to not be there to tell them. I called my middle son, my oldest son, Michael. I told him, I don't even think he even heard me. And the reason why I say that is because a couple days later, he called. He said, Mom, what's going on with my little brother? Why haven't you called and told me anything? I said, Mike, Ty is gone. And he just lost it. He was like, what do you mean he's gone? I said, I told you Ty didn't make it. And he lost it. And then I had to call my other kids. My middle son, I had to call him. And then my god kids, and everybody just started. Everybody knew at that time. Yes, that was the most hardest thing that I ever had to do as a mother, as a parent, to tell the siblings that your baby brother is deceased, and really for no reason. No reason at all.
As well as at the time that Ty passed, how old was he?
Ty was 29. He was a 29-year-old young man, still trying to find his way in life. You know, he hadn't found his way yet. He was getting there. He loved to skateboard.
As well as, I'm gonna pass you a picture. Can you tell the jury what you see in that photograph?
My happy Tyree.
And is that what Tyree looked like that day he left your house on the afternoon of January 7th, 2023?
Yes. He didn't have on his suit, but yes.
Your Honor, I would ask this be marked as Exhibit 2.
Let's go ahead and first enter the stipulation on the record for Exhibit 1, and then we will show the picture of Tyre Nichols as Exhibit 2.
Your Honor, permission to publish. And Ms. Wells, looking up at the TV screen here in the courtroom, is that the photograph of Tyree?
Yes.
Is that what he looked like that afternoon when he left your home?
Yes. Yes, that's what he looked like.
And Ms. Wells, after this occurred, you had been told, you mentioned that the officer said that night that Tyree was nearby.
Yes, nearby.
Did you later find out that the events in this case happened at Castlegate and Bear Creek?
It was later on. Actually, my son, they were looking at different videos and things of that nature, and they realized that this had happened in a neighborhood. And as they started putting two and two together, they realized that it had happened in the first cul-de-sac of our subdivision.
And tell the jury, if you can, about how far from your front door to where this happened, that cul-de-sac where Castlegate and Bear Creek is, how far away is that?
About 80 to 100 feet.
Ms. Wells, I'm going to pass you another photograph. Ms. Wells, do you recognize what's in that photograph?
Yeah, I recognize
And can you tell the jury what you see there?
my son beaten to a pulp
And where was that picture taken?
at St. Francis Hospital. My husband actually took this picture.
And is that what he looked like when you first saw him?
Yes. As we were walking in, and I saw him, and as I was walking over towards him, my husband took this picture.
Your Honor, I ask this be marked as Exhibit 3.
Any objection? Also, the photo of Mr. Nichols in the hospital as exhibit 3.
Your Honor, permission to publish. Ms. Wells, looking at the TV in the courtroom, is that photograph you just looked at?
Yes.
And is that what your son looked like when you first saw him that night?
Yes.
Or the early morning hours of
Early
January
morning.
8th?
Yes.
At some point after Ty passed, did you all have a memorial service for him?
Yes, we did.
And when and where was that, Ms. Wells?
It was approximately, I can't remember the date.
That's okay.
I'm drawing a blank on the funeral home, and I'm drawing a blank right now.
That's okay. Did you have a service here in Memphis?
I did. Ty actually had 2 services.
And if one was here in Memphis, where was the other?
Both of them were in Memphis.
Okay.
Yes.
Just one moment, please.
Well, something in her testimony, they,
You want to repass the witness?
All right, Mr. Saint, or Mr. Lutton.
Thank you, Your Honor.
cause I ran it back.
My name's Steve Lutton. I'm going to ask you some questions. I'm going to refer to your son as Mr. Nichols.
Thank
I think he
you.
deserves that respect.
Thank you.
And so if I use Mr. Nichols, I'm talking about your son. Not only are you the mother of Mr. Nichols, you're also the administrator of the estate, is that correct?
Yes.
And as the administrator,
Your Honor, may we approach?
Okay, so at this point, they still, deliberating on the sidebar. If I bring this current, they're not here. So I will be back tomorrow.